Weekly list was Monday.
It was on Monday.
We'll see which let's move that up.
I'll only take not more than 5 minutes. 3 minutes I'll take. I've given a written note of argument.
3 minutes by time. By what? By what?
By what? By the what?
By what? So what? Because you are 3 minutes.
It's 3 minutes. By the what?
Yes.
I don't know. But material was interfered and directed for the notice. Notice has been served upon them. The rejection of 216 application by the extent of the prosecution. And the case is posted today for further examination of the IU.
Which item you are talking?
When I claim are taken up tomorrow, one out of this thing. Your lordship was interfered and it should be noticed that the rejection of 216 application. 1, 2 to 3 accused. That is the reason why, my lord.
What is the reaching urgency?
Urgency, my lord, your lordship was no entry protection has been granted. Now the IU has already been examined and it is for the accused. Can I take it up?
You just give the memo here.
For tomorrow because the
Not tomorrow, not possible. Because when have you filed the petition?
it is my lord 2 months after your lordship has interfered and
That's right. You file 2 months before. Tomorrow, see, this entire system is getting derailed. That is the whole difficulty. I'm trying to, systematize.
Yes.
1 matter, 2 matter.
Next Monday can I?
I'll just check it up. I'll see the file and adjust. Yes.
Because the prosecution has moved this.
Yes, we'll see it. Yes.
My lord, matrimonial dispute settled in between husband and wife, but criminal case proceeding pending against husband.
498.
Compromise.
But the parties have to be there. My lord, without me.
Item 58, your lordship, I pray for an adjournment. May kindly taken up next week along with CRLMC 4134/2021.
58.
Yes. As per your lordship direction, I have found a criminal misdeeds that was numbered yesterday, your lordship. So let it come next week along with
Let it be list.
4134.
Notice also not sufficient.
No, that last order was there. IO was personally applied and prayed for time. But opposite party number 2 was not applied and it was directed to
On request, list the matter put to me chadi ki de diyo. And along with
4134/2020.
yes.
Your Lordship, I'm mentioning item number 70 on behalf of Mr. Ashutosh Sahu, the arguing counsel. He has some personal difficulty today for that, Your Lordship, if it kindly be adjourned
So
after a
this
week.
is a matter of 2020.
Yes, Your Lordship.
There must be some interim order. There must be some.
Your Lordship. So far, we recollect there's no interim order in this matter.
No interim order is there? On request.
Grateful, Your Lordship.
Item 59.
59.
Requisites have lately they have submitted requisites, so notice has to be sent.
Sorry?
Requisites we are given lately.
Huh?
Requisites we are given our time but
Why? So why are you given late?
I was in Bhavani Patna, my lord, I can't give it, so I came here.
No. There is an I'll impose cost.
Come, my lord.
Because see, there is an interim order.
Yes,
You take the interim order and don't file the process fee. This has been a practice.
no, my
So therefore, that is the reason I am not giving interim orders.
lord.
This has been a constant practice. You take an interim order, don't file process fee, requisites, and thereafter you come and seek adjournment. And it will be pending.
My lord,
For
we are given,
10 days.
late we are given. After 10 days.
I'll vacate the interim order and pass.
No, my.
Vacate the interim order. No. This
Given requisites.
because of the conduct of you like litigants, and the other people are not getting interim orders.
My lord.
Why you see this order was passed when the order was passed in March,
March, my lord.
and you have enjoyed about how many months you just see?
We are given requisites we are given after 10 days. But
Why have you given? Because the interim order is next. I started writing in the orders that if the requisites are not filed by tomorrow, the interim order shall be vacated automatically.
But in Bhavani Patna, virtual could I move it, but in that system was not there to give the order.
Pay 1,000 cost.
My lord.
1,000 cost.
Right.
Right. By the order dated 20th March 2024, notice was issued to the opposite party number 2 and the interim stay was granted in favor of the petitioner. However, the petitioner has not filed requisites requisites for the purpose of serving opposite.
My lord, we had filed the requisite. It was also.
In time.
In-
I filed the requisite in time. Lieutenant Counsel for the petitioner seeks an adjournment today and submits that the requisite file belatedly may be utilized for the purpose of serving notice on opposite party number 2. The requisite filed by the petitioner belatedly may be utilized for the purpose of serving notice on opposite party number 2 because of the belated filing of the requisite before this court. The petitioner is saddled with a cost of rupees 1,000 to be deposited with the bar associates. Yes.
Beg to pardon, my lord. I beg to pardon, my lord. The petitioner is accused in the NI Act, my lord. And he filed an application for sending the handwriting, the signature to the expert, my lord. And that was rejected. Against that, he filed this application before your lordships. And now the said NI case is still pending, my lord, due to stay order. If your lordships kindly agree, I am the opposite party. I am
Give it to it.
Whatever was passed on the section 148 of NI Act, to decrease from class, the petitioner could not arrange, so that the order was cancelled. They are taken into custody. So I have filed a for it. So now I am ready to deposit. So
You are ready to deposit?
yes, not.
Huh?
So I have filed for it.
Are you ready to deposit?
Yes.
How much? What is the check amount?
Now total 140 order against that is $48,000.
Huh?
Approximately 48,000.
14,000 only.
48,000.
48,000. Release it tomorrow and come with that draft.
And that will be because it is not code below.
Okay. Tomorrow. Huh? Tomorrow. Yes. You are in custody.
Yes, ma'am.
Okay. Yes.
pardon to mention, your lordship, sir. Lordship, on matter, your lordship was pleased to refer to mediation center, which was between sister-in-laws. So, my lords, what has happened by virtue of that, Lord Mediator has directed to dispose of the civil suit that is pending for the civil court, wherein that is a suit for partition. And there are other two shares whose
What do you want?
I'm including in this matter and I need a modification as to respect that the order that has been given that the civil suit and production of a document, the civil suit will be disposed of, that has to be modified because that's a suit for partition and that in the mediation have to tell all this thing. How can I do it? Because that
I only connect to mediation. Mediation problem is that you don't tell that I'm also a party. I should be disposed.
that has been acknowledged by your lordships and order has been passed. So that is why I need a modification.
I have accepted the mediation report. That's all.
That will do. I have filed a modification and an intervention. If your lordship pleases,
Take it and list it. And I will see. Yes. Sorry?
Item number 13, my lord.
13.
Yes. On
Yes.
behalf of Mr. Lalitendu Mishra, I pray for my lord 2 weeks adjournment, my lord.
Sorry?
On behalf of Mr. Lalitendu Mishra, I
Huh.
pray for a short adjournment, my lord. Item number 13. Yes.
December.
item 3, my lord. On behalf of Mr. April from 1 capital to no short adjournment, my lord.
See, this is the problem. We are adjusting the list in such a manner that all the matters will be taken up. Once it is listed, you ask for adjournment. What is this? I don't know.
Pardon, my lord, here's some.
List it in January. List it in January.
In.
Now, whoever is asking for adjournment, fresh matter, list it in January. Yes.
This matter, by the order dated 6/9/2024, the matter kept for mediation matter. Mediation report has not been received.
Mediation is going on.
Mediation, so far our instruction failed. The report is yet to be received.
Okay.
So,
Mediation report has come. Final
final report, interim report might have.
unsuccessful.
Unsuccessful.
Unsuccessful. Your Lordship may kindly fix a date for hearing.
Fixed mediation, the matter was referred to mediation. However, the mediation, High Court Mediation Center has submitted a report dated 4/11/2024, stating that the mediation became unsuccessful. Leaves the matter for hearing in December. Yes.
Date may be fixed, my lord.
Yes.
The interim order continue. There is an interim order.
Interim order to continue. Yes.
Item 2.
Yes.
Item number 2, Your Lordship, I'm here to BC. In this case, we have prayed for the matters to be handed over to the independent investigating agency like CBI or the crime branch, Your Lordship. What has happened in this case? On March 1st, 2023, I'm the petitioner.
Just a minute, we have filed a counter affidavit. Please go through that. This is a matter, my lord, that a young boy and lady was there in the Hirakud dam, my lord, in there. And thereafter he fell down and on drowning she was died. Police took up the investigation. And so far there is no foul play. Police got the investigation so far.
Your
But
Lordship,
yes, then he wants to we have filed the my lord, the polygraph test of that accused, which he claims that he is the accused. And other materials are there. Let him go through that. And also the postmortem report shows that this is the dowry. Have you gone through?
Your Lordship, as far as my learned,
1 minute. Have you gone through the counter filed by them?
Your Lordship, we have gone through the counter affidavit. They have stated that they have the post-mortem report shows that the case is of anti-mortem drowning and accidental drowning they are talking about. Lordship, if you look into the post-mortem report, they have stated that the deceased had taken 100 ml of water, whereas the depth of the water was 7 feet in nature. That was
You have a remedy of filing a protest petition. You can report to that.
Your Lordship, the protest petition, along with that, we have filed one IA to stay all the proceedings because when the dead body of the deceased was recovered, just for
The investigation may not be to your satisfaction, but the fact is that the investigation has been done very diligently, and they filed this counter. Just see the counter.
Comprehensive, everything
May I be
taken into
permitted?
consideration.
Your Lordship, may I
May
be
not be to your liking, may not be to your satisfaction. That's a different story. Therefore, the code provides a different remedy for that.
Your Lordship, I completely appreciate your Lordship's concern, but here is this case. When the dead body of the deceased was recovered, there was a ligature mark in the middle portion of the neck. They have stated in the post-mortem that when the dead body was recovered, it is not a case of strangulation, whereas the wearing apparels has been created an impression marks. That raises a serious doubt. Second thing is that when we went itself to the CBI office, the officers itself told that it is a case of strangulation. The most important thing is that there was not a single recovery of the mobile phone charger which was been recovered from the hands of the accused. Second, there were the gold chain being missing from the deceased neck, Your Lordship. I am the petitioner mother. After 6 months, her father also expired due to shock and heart attack. So leaving behind younger daughter.
Okay, then you file rejoinder to the reply to the file. We'll see. File the rejoinder.
Your Lordship, may I kindly be granted 2 weeks time to file the rejoinder because it's
2 weeks time granted to file rejoinder. Please
Yes,
the
sir.
matter. Yes.
Item 4.
This variance has been filed to speedy disposal of the case within a particular time frame. The FIR was registered on 7/5/2015. After that, I filed Joseph Millard.
Your Lordships,
After that, a complaint.
here is a case, my lord. This honorable court has directed Lordship kindly see the last order
Yes.
to obtain instruction from the SP whether the imbue has been carried out or not. And the fact remains he has submitted some false stories. For that reason, this court has directed for this is the report matter. And imbue has been issued matter that has been carried out. Thereafter, another case was he has filed, and on that basis, on 28/7/2004,
he was arrested and forwarded to the court and has been released. If the witnesses will not come, my lord, how this petitioner will likely?
No, no, after filing of this CLMC application, he was arrested in the execution case, not in this case, my lord.
But you have stated that the warrant has not been executed.
No, no, this warrant was not executed while I was filing
The
that.
warrant is not there at all.
Lord, after the,
Kindly see the report, sir.
Yes, out of 22 witnesses, 9 witnesses have already been examined. What do you want?
I want the speed disposal of the case.
Then have you seen the report of district and sessions as Vedrak has given, and it is going on a expected pace.
My lord, that was filed, if there was in 12 cases of everything, my lord.
There is NBW issued against you
Yes,
because you have remained absent. Then the delay is attributable to you, and you can't force now. Why have you not gone? Why NBW was issued against you?
against me.
It is every steps, my lord.
Oh.
He has not come to the court for that reason. This delay.
Right, the NBW, accused persons, NBW was issued on 27/6/2017. And that means there is no cooperation from the accused persons. How many accused are there? How many accused persons?
My lord, in this case, my lord, yes.
The matter was taken up for hearing on 16/8/2020.
My opinion, some is the meeting, so let me hear.
The coordinated bench of this court has passed the following order. Okay. Next, pursuant to the aforementioned order, the district and sessions Bhadrak filed a letter dated 6/9/2024 has submitted as under. Paragraph is spoken for the
My lord, I am.
Okay, I have perused the report and and satisfied that the trial of the case is proceeding at the expected pace. Out of 22 witnesses, 9 witnesses have already been examined, and the material witnesses are yet to be examined. Therefore, the matter, however, material witnesses are yet to be examined. It is next forward. It is accordingly expected that the trial court should do well to see that the trial is completed as expeditiously as possible. With an expected pace. Take it. Dispose of. It's next.
Item 5.
I plead your mercy.
Mercy, here,
Yes.
I plead your mercy. But here the NBW has been issued against the petitioners. The offense alleged section 492, 494, 506, 406 and 34 IPC.
Yes.
The petitioner one is the husband and the second is the wife, second wife. And in the meantime, the charge sheet has been submitted and the NBWs have been issued during the
What is that NBW order?
your lordship may kind of have a glance to page last page.
18.
Yes.
Yes.
The order of convenience dated 30th March 2021. Second paragraph, the accused person are absconded. Second paragraph I am placing. NBW has been already been issued on 14/2/2011.
And it won't appear.
That's my
Time, right now. In the petitioners, how many petitioners are there? The petitioners are including FIR numbers also. Subsequent to the filing of the charge sheet by order dated 30th March 2011, the court of JMFC P. Kujango has taken cognizance of offences punishable under section 498 capital A 494/506/406/34 IPC. Next further. Since the petitioners, since the charge sheet was filed showing the petitioner to be absconder, the court below, while taking cognizance of the offence, had issued NBW against the petitioners. Hence, the petitioner is aggrieved and approached this court by filing the present petition. On the instruction from the petitioner, learned counsel for the petitioners, learned counsel submits that the petitioners would be appearing before the court on or before 30th of November, and resort to the remedy available to them under law, with for the on the basis of the aforementioned facts and circumstances, and taking into consideration the submission made by the counsel for the petitioner to the bar. The NBW issued by order dated issued by JMFC Kujango by order dated 3/3/2011 in GR case number 67 of 2010 shall remain kept in abeyance, shall be kept in abeyance till 30th September so and so. The petitioner shall appear before the court and resort to the remedy available to them under law as per the stipulation. As per the stipulated available to under law, subject to the petitioner depositing 1,000 cost. Yes.
Item 6.
Here, the office alleges section that the petitions are employees of a bank, Union Bank of India, and allegation against them, they are misappropriating 14,86,000 during their incumbency at the Paradip branch. Let's see from the charge sheet, let's see back page 17. It has been stated that the misappropriated amount of 14,86,000, let's see page 17, paragraph 2.
Yes.
Sentence starts from during investigation, but we are at 1, 2, 3, 4, 5, 6, 7, 8 lines from the paragraph 2. Investigation so far revealed that the accused persons, let's see, one is Amarjit Panda, 2 is Saurabh Soren, 3 is Sangram, and 4 is Sibo Sankar Mishra. Misappropriated sum of 14,86,716 from Union Bank of India during their incumbency at Paradip branch. And they deposited the same because the Union Bank of India government branch.
You say that they were misappropriated and deposited, so the crime is gone.
Later on, they deposited
The crime is gone.
criminal liability there. By mistake it has been done.
And then the complainant has to come and say that yes, I will withdraw it.
Yes, your Lord.
You bring him if you want.
Complainant is the branch manager.
But you have to bring him.
Your Lord,
You are under his mercy now. Court can't do anything.
I have not made parties here.
So you make the party and take out notice. If he can come and will not oppose, then that is different story. Right on. And then counsel for the petitioner seeks to implead the informant in the present case as the opposite party number 2. Issue notice to the newly added opposite party number 2 of written. You do it. It is paperless. You have to paperless. You have to file new more. Yes. Yes. Seven. Password.
Item 8.
Another petitioners pray for passing of the order of cognizance dated 17/1/2005, my lord, had annexed to in marriages out of the matrimonial dispute. In the meantime, they have compromised. So let notice may be issued to open number 1 and 2 so that notice
Matrimonial dispute.
they have been made included as parties, my lord.
No, settlements, they married what?
They were married and there was some dispute, so FR was law.
I understand they are staying together or separated.
Now the divorce has been allowed, they have annexed.
Okay, issue notice written good also. Then counsel for the petition submits that the matter is arising out of a matrimonial dispute. The parties have now settled the dispute. And the petitioner number 1,
2 and 3. Husband is the petitioner number 1.
petitioner number 1 and wife is petitioner
Number 3. OP number 3.
no, number 3. The marriage between the petitioner 1 and opposite party number 3 has already been dissolved.
Yes.
Persons to the settlement. Settlement issue notice written also. And the meanwhile, and can you bring them?
Within 1 week, my lord.
1 week, please the matter. Yes. 9.
Your lordship.
Yes, sir.
The petitioner is filing the petition before the lordship to quash the criminal proceeding against him. The background of the case is, my lord, the incident
Another CRLNC was filed, my lord.
that was withdrawn by
That record.
that was withdrawn with the permission liberty to file the appropriate petition with the relevant documents. That was CRLNC.
I was given declaration to that effect.
Declaration was there.
And I challenge in that, Madam CRLNC. Again, was withdrawn. My humble son, sir, my lord.
Withdrawn with the liberty to file a better application.
Where is that order?
Se orderটা আছে সে orderটা আমি দিয়ে দিন আমি লিখেছি I have
Where have you written? Show me.
just your lordship may turn to page 2.
Page 2. Yes. Yes.
Disposal was withdrawn on 13/1/2000 as per the instruction received from the petition.
Liberty is granted, they are sure. The liberty is granted. Let us with that file. We'll see if the liberty is granted, this is a fresh petition. I go by your statement. I go by your statement. Liberty is granted.
Of 2000.
Take it out, take that order. Yes. Unlike you tell me, what is the case? What is the case?
The case is initially registered on section 307, Railway section 120B.
Yes.
And 34 of the Indian Penal Code. While the incident was occurred while the two injured persons were passing in their car, 4 persons hurled bomb and they fire causing injuries. In the year 2016, a person was arrested, now the present petitioner, and on his confessional statement that I conspired with him, resultantly the occurrence took place. So far the initial story, 4 persons assaulted, they gone back. And that man faced the trial. Ultimately,
Out of the 4 people, or is it separate?
charge sheet was submitted against 2 persons.
Out of these 4. Out of these 4. Yes.
Man accused who threw the bomb and the present petitioner as the conspirator. And that man accused faced his trial. And ultimately, he was acquitted because there was no evidence against him. I filed a
Where is that judgment?
judge annexed 5, my lord.
Yes. Where are the findings?
Paragraph 8, your lordship.
In the same page, your lordship may see.
And whose confession? The same accused who has been.
Accused made a confession, the accused made a confession before the police.
Yes, tell me.
It is not there, my lord. The CD is not passed.
There is a legal issue now. Legal issue is if you are implicating someone
My lord.
on the basis of a confessional statement of a co-accused, and that co-accused faces the trial and get acquitted, what is the value of that confession?
The name, in this case, my lord, the accused, this witness have been examined. And he is.
That's right, but he is acquitted. And you are done.
This petitioner is implicated by that persons.
Which person? This person.
Present petitioner.
And he is acquitted now.
Not acquitted. This, there is a.
ଆପଣ ଦେଖିଛନ୍ତି କେସ୍ ଦେଖିଛନ୍ତି ନା ଦେଖିନାହାନ୍ତି ଟାଇମ୍
Acquitted now.
ଟାଇମ୍ ନିଅନ୍ତୁ ଦି ଜଣ ମୁଦାଲା ଯିଏ ମେନ୍ ଆକ୍ୟୁଜ ଯାହା ଆଲିଗେସନ ଥିଉ ବମ୍ ହି ଫେସ୍ ଦ୍ୟାଟ୍ ଟ୍ରାଏଲ ଆଣ୍ଡ ଆକ୍ୟୁଟେଡ୍ ଆଇ ୱାଜ୍ ଇମ୍ପ୍ଲିକେଟେଡ୍ ଅନ୍ ଦି ବେସିସ୍ ଅଫ ଦ୍ୟାଟ୍
His confessional statement.
I'm like. Initially, the case was registered against two persons.
नो अगेंस्ट फोर पर्सन
Out of that, man, one person was arrested as per my records. And he was first tried.
One person was arrested. Two persons were charged sheeted. Out of them, one person has faced the trial, and the same guy has given a confessional statement implicating this petitioner. Now he is acquitted.
That part is not with me because it is not there. First time this case has come. And second part, my lord, in this case, my lord, there is evidence is collected. Investigation inquiry is going on. Trial is going on. In this, in that case, he stated this petitioner is implicated. He has implicated this petitioner.
ଆପଣ ପଢିଛନ୍ତି ରେକର୍ଡ ଆଜ୍ଞା
I am sorry to say he is getting bit confused. Let him concentrate. Allow him to concentrate.
ମୁଁ ସେଥିପାଇଁ କହିଲି ଆପଣ ପଢି ଦିଅନ୍ତୁ ଭଲ କିରି
ସବୁ
ଆପଣ ତଳେ ଘରେ ହୁଅନ୍ତୁ ଗୋଟେ
Aram sir.
ଆରାମସେ ପଢନ୍ତୁ
Mr. Jena, this is he has withdrawn with liberty. This order I have got. Yes.
Your lordship may keep it some other day. I will also obtain the CD because he is saying that on the confession statement of that accused,
What is the stage now? Insofar as this accused.
So for this he is on bail and his case has not yet been committed.
Not committed. Okay, issue notice and file reply.
I am suggesting one thing. I friend may call to the CD, examine the CD and the evidence and the entire thing so it will be very clear.
Yes.
again.
Call for the CD, call for the CD, leave the matter after.
Item 10.
You have an IA? No.
Item 10, may I please, my lords. Lords, last order dated 28/8/2024 may be seen, madam. 28/8/2024 last order.
Yes.
Lordship may just have.
Case date मागितले आज.
Case date होगा ही नहीं sir.
Or instruction मागितले.
Instruction होगा इतना जो whether sanction was obtained or not. Lord, this case is
General and counsel for the petitioner state submits that he has not yet received the case diary.
case diary is not required in this case. My lord, sanction. It is a case of.
order टा भी शीत्र थी वो ना case date मित्र से ना पढ़ता हो.
Get the first time he can lease the matter after 1 week. Huh? Yes.
My lord, the interim order to continue.
Interim order to continue.
My lord, may I pray that on the last occasion, interim order was passed for an application to be filed before the land court below.
The same arrangement will continue.
My lord, short date may be fixed.
Yes, yes.
Because
After
I'm waiting
after
for-
1 week. Yes.
Item 11.
Yes.
In this case, my lord, the civil matter turned to criminal proceeding, your lordship. I will take 30-second, my lord. A piece of land belongs to my lord, Somnath Barik and Panu Barik. Both are husband and wife, and they have 5 legal heirs, my lord. 2 sons and 2 daughters. One out of 5 legal heirs, my lord, filed in partition suit before the learned court below, while Sibo Suit number 7399 of 2014. After 7 years, Your Lordship.
Who is Hemant Barik? Is your brothers? Your brother, one of the brothers.
Hemant Barik are the
Informant.
yes, my lord. Hemant Barik, three persons are there, Your Lordship, in this matter. Who are filed petition under 257 and they withdraw from the proceeding. The only petitioner is there, my lord, that is Hemant Barik. Three petitioners before the 1cc matter, my lord. The two withdrawn the issue. But my lord, what happened? Son of Narayan Barik came to know that the petitioner forged one sale deed. The sale deed dated is 13 November 2021.
Right.
For that reason, my lord, the complainant number 2 and his henchman, complainant number 1 and 3, filed the complaint case, Your Lordship. Thereafter, on 22 November 2023, the complainant number 1 and 3 filed the petition under 257. And they say that we have no doubt, no sale deed is prepared or no sale deed executed, so we withdraw this. Your Lordship. Page number 28 may kindly have a glance, my lord.
28.
Your Lordship.
Okay.
Complainant namely, third paragraph, my lord.
So initially there are three complainants.
Three complainants.
Two complainant withdrew.
Withdraw.
And this complainant Hemant is carrying on now.
Okay, he is not the primary complainant, Your Lordship. The primary complainant withdrew from this case, Your Lordship. He stated, my lord, the complainant namely Vidyadhar Barik and Sukant Barik is present, file Hazira and file petition 257 CRPC on the ground stated herein. The petition is allowed. Complainant Hemant Kumar Barik is present, my lord. He is directed to produce the original document on dated fixed on 8/12/2023. It is interesting, my lord, what happened. They said we forged one sale deed. That must be recorded from, my lord. So for that reason, my lord, we filed a petition before the 11th court below. If such sale deed is forged, then produce before the court. Your Lordship is not producing any. That's why, my lord,
Direction is not complied.
not complied since 2022, my lord. The case is lingering, Your Lordship.
Alright, here it is arising out of a complaint case, man.
Yes,
Three complainants were there. They are all brothers. The property is issue notice. Written,
I am not placing the IA, but Your Lordship, I am requesting no further adverse order may kindly be passed by the learned.
I'll stay the proceeding.
Oh, great.
I'll stay the proceeding. I'll stay the proceeding. Further proceeding. Yeah? Because once it is not stayed, it will be aggravated. You ultimately you are brothers.
No.
It has to be settled.
But my lord, the fact is, my lord, no sale is executed.
Anyway, we will
It
settle.
is only presumption. My lord,
You let him come, settle it through mediation.
my lord.
Well, brothers are necessary. Yes.
Grateful, my lord.
Yes. Further proceedings. Yes.
My lord, I have filed this application, my lord, for quashing of the affair on the ground of compromise. That both the present petitioner and the present informant, my lord, both are the co-staff, my lord. One is working as the health worker and another is the pharmacist. They both fall in love with each other and continuing their life, my lord, as husband and wife. Thereafter, my lord, some disturbances started. And in the meantime, for which, my lord, affair was lost. And in the meantime, my lord, they have settled the matter and they have no interest at all.
Where are they?
Mangalbar dina asu, they will present both.
It's 493 only.
Aye. They will both present and
Yes. Mangalore. Yes.
publish.
Joint affidavit also you have to file.
Aye. I'll go to sir.
Mail please.
Can do one also.
Mail please.
First.
Mail please. And in this case,
30.
Yes. Yes.
item 15.
No, 14. Not, he is there already. Yes.
Item
Yes, I can hear you.
14.
Yes, Mr. Ray.
I'm from Bishimir. Item 14.
Yes, yes, I can see you and hear you also.
Kindly one password your opponents.
The argument is over. Now,
In this case, we are. Yes, and
this is what the argument is. It seems. Get pass out.
One pass.
50. Please,
Yes.
I'm not telling this.
Yes, sir.
It is not telling this. It was proceeding initiated against him under the SC/ST Act.
Yes.
Your Lordship will kindly see my petition I am giving it. The petitioner has dispute with his brother. He has filed a civil suit. Both are contesting that.
Yes.
Thereafter, 144 proceeding was initiated. And it was then converted to 145 proceeding. The order is, the interim order is, Your Lordship will kindly see at page 5.
5.
Page 5.
Okay.
This was necessary, 144 proceeding was necessary because he was taking steps to make constructions on this place because it is a joint place and the petitioner wanted that it should be stopped. And in the suit also there is an order for maintaining status quo. Now what happened? Your Lordship will kindly see page 5.
I'm there.
My Lord, the order passed by the Honorable Magistrate.
This,
in spite of this order, the informant
145, one order status quo to be maintained.
Status quo.
145.
145 against status quo. In spite of that,
this 145 order will remain in force for 6 months only.
This will remain, 144 will remain for 6 years. That's
what I'm saying. Not in the civil suit, there is another order.
In civil suit,
there is that order.
I have given that.
Where is that order?
I said 3 or 6. No, I have heard that. Para 5 is 3 para 5.
Yes.
In the meantime, what happened is a worker of the brother who is in dispute with me. His man entered into the place. I assisted that. He had now lodged a report. I had gone there. He admits that there is an order from this 145 proceeding. But I went there, he told me contra, etc. I am telling you that.
But how will you get out of the allegations? Maybe that is one of the motives. But the fact remains that there are allegations.
Yes.
How can I cross it?
No, because the circumstances will lead to this assertion. Let them also submit what is their investigation. Because
you have to make out the case for yes, there was proceeding pending. That may be the reason you might have done it.
The other thing is he admits that there is a stay order from the court.
That's right.
And thereafter he had no business to go there. He had no business to go there.
He had no business to go there since even then he went there. Therefore you scolded him.
That maybe I don't dispute that presumption will not
no. So this is only that I think it is very preliminary stage. It has to be, notice to whom you have included. You have not included the relevant party. Where is the informant?
Informant party is not a party.
That he is a necessary party. In this kind of, if you say it is a civil dispute, blah blah.
Brother.
Right, but there is a mention, there is 145, one order.
He is a brother. He is an employee of the brother. He is a party in the petition suit.
If you don't satisfy me, why should he be issued?
So many incidents I have given.
So that may be the reason for this FIR.
When he himself admits He has no business to go to the place.
That's right.
There is interim order from the court.
Even then you went there. Therefore you scolded him.
I refuse that.
That's the reason you have
I refuse that.
That's what his case is.
I refuse that.
And you may refuse, but it has to be established.
That has to be considered, my lord. Once I win some reason I have given.
Simply issue notice, let us say, I am not satisfied. Still I will issue notice. Okay, issue notice. Yeah. Still I am not convinced. Still I am issuing notice.
I have given out some reason. Some reason.
A reason to be established in the trial.
That is another thing, but some reason given.
I'll just issue notice. Let us. Yes. Next.
I am filing an IA. Your lordship has said that.
I am so reluctant to issue notice.
If I file a petition,
then is indirect. After 1 week you bring in. And include the informant as a respondent. Liberty granted to the petitioner to include the informant in the present case as respondent number 3. Issue notice to newly added respondent number 3, written within 1 week. Mr. Naik accept notice, waives notice for the respondent 1 to 3. File the process. I notice on IA.
No.
Yes. Yes, next. These are paperless. Everything paperless, sir.
What is in the list?
Paperless, you have to file. Memo also you have to, amended memo of parties also you have to file. Yes.
16. Your my lord, the private opposite party number 5 to 8 my lords, running my lord ground of mill in the residential premises of the village my lord. Your lordship kindly see from page 14. A 133 proceeding was initiated. Paragraph 4, your lordship kindly see the SDO my lord, as per inquiry found that the respondent running their mills day and night in their residential houses, as a result of which the waste product of download are entering into the dwelling house of the petitioner as well as the residential house of south side of Swanso Street, for which it creates unhealthy atmosphere and it does create a dust allergy and suffocating to the local people. Thereafter, my lord,
this you are asking a mandamus.
Now, my lord, after the closure, my lord, now also
can you maintain this prayer?
My lord, unless your lordship direct the opposite party,
the prayer.
Yes, my lord.
In a proceeding of this nature, can I give this direction?
Direction to the police, my lord. To the police, my lord, unless your lordship direct, my lord, they will not evacuate, my lord.
That is a different story. What is the jurisdiction you have invoked? And what is the direction? You are asking for a direction to opposite party number 3 to take immediate steps regarding the evacuation of groundwork establishment. You have to file a writ petition. Not a 482 proceeding.
Against 133.
No, I am not challenging the order of 133. 133 is in my favor.
See the prayer.
No,
prayer in a
3 and 4 to take immediate step regarding the evacuation of download unit established by the opposite party number 5 and 8 in the residential village of Swanso.
Writ petition you have to file, sir, not 482. 482s are not meant for this thing. You have to file a writ petition.
Then your lordship,
I'll give liberty. Counsel for the petition, keeping in view the nature of prayer made in this petition, I am not inclined to entertain this petition. Therefore, the counsel for the petitioner seeks liberty to withdraw the present petition to file a fresh petition in accordance with.
Your lordship, my oral prayer converted to CRLMP.
Then it will go somewhere else.
My lord.
No. With this liberty, the petition is disposed.
17
and proceeding, my lord. What happened in this case, my lord? 2 persons has been killed by the villagers. Suffering them is a witchcraft, my lord. And at the time of occurrence, my lord, the petitioner was a minor. And the offer was lost
against unknown person or unknown person of that place, my lord. Subsequently, during course of investigation and after completion of investigation, the charges submitted against the others, my lord. And Cognizance was taken by the land to do against that person. His involvement is doubtful, because they say, my lord, that
At this stage, the involvement of accused is always doubtful. It is to be established at the time. Doubtful only, otherwise you would have been convicted on the police paper only. But since it is doubtful only, therefore there will be a trial.
no, so far the my involvement is concerned, my lord.
It has to be established in due process. You can't curtail the process like this. Maybe you have a good defense. Doesn't mean that at this stage court can interfere. It is only Cognizance says.
Cognizance has been taken, my lord.
Taken.
And
The material is there.
and the unwavering is put in the petition. So
I'll stay the NBW, go and appear and madam, sure, right up. Petitioner is agreed by the order dated 2/8/2018, whereby cognizance for offences under section.
my lord, under section.
No, cognizance is taken earlier.
My lord.
No.
147.
Petitioner is agreed by the order dated 15/1/2013, whereby cognizance for offences punishable under section 147/148/302/201/149 IPC has been taken against them and against the order dated 2/8/2018, whereby NBW has been issued against the petitioner. I am not inclined to entertain this petition at this stage. However, insofar as issuance of NBW against the petitioner is concerned, the same needs to be interfered with. Next one. The petitioner on instruction submits that his client would be appearing before the court on or before 30th of November. So and so, and resort to the remedy available to him under law. Taking into consideration the aforementioned and the submission made at the bar, the execution of NBW issued by the court of SDJM Malkangiri, while order dated 2/8/2018 shall remain kept in abeyance till 30th of November, and the petitioner is given liberty to appear before the court, appear or silent before the court by that date, on or before the date fixed, on or before the date fixed, and resort to the remedy available to him. With this observation, petition is dismissed.
18.
On behalf of Mr. Pradhan Rosime, permit me to submit assessment. Was case under section 13 to reduce section 13(1)(e) of the PC Act. Petitioner is working with
By the way, you look better this side.
Plus, he is working as assistant sub-inspector of police. In 2016, his house was raided. Thus, FIR was registered. Investigation taken up. To the investigation, the petitioner came up before the Honorable Court, stating that in that the property house which has been taken into account is his assets doesn't belong to him. It stands in the name of his father. So this should be deleted. Yes. And the Honorable Court were pleased to allow that petition, and the house property which was sold to the asset of the petitioner was also deleted. It was more than 40 lakhs. And thereafter, charge sheet was now submitted. He came before worship for crossing of the proceeding, and during that proceeding, they filed an affidavit that even though the DA comes to 67%, however, on reassessment, it comes to 117%. That was the affidavit filed. However, your worship, this was pleased to quash the proceeding against him. Vigilance went to the Honorable Supreme Court. The Honorable Supreme Court remanded matter saying that opportunity was given to file the charge sheet. Accordingly, they filed the charge sheet. Here, because he is a class 3 employee, there is a circular of the DA department, Vigilance Directorate, that any DA less than 100% in respect of class 3 and class 4 employees should not be allowed to continue. Here, the admittedly charge sheet is that the DA is 117%. Your Lordship, may kindly come to paragraph 17 of the petition, my Lordship.
17.
Yes, 17, page 17, my Lordship.
Yes.
Here, Lords, some properties have been sold, standing the name of the wife of the petitioner has been sold to the assets, Lords. But admittedly, those properties have been sold since 2006, 2012, 2013, and the date of FR is 2016, Lords. And that has still been
So
sold.
it must be during the checking period.
But it has been sold, Lords. So when the property is not there, Lords, how can they say that it is assets, Lords? Property has been sold, but it is within the check period. But on the date of lodging of the FIR, they show that these properties are the income on the income side, Lords. When the property is always stand in the Lords, is not there at all, Lords.
What about the sale proceeds?
No, that exactly saying, Lords. One is not. Supposing that it's shown as the Bemler's income. Once it's shown, Lords, it is not nullified, Lords. Ultimately, it comes to zero, Lords.
Not zero. The sale proceeds is there.
Look, Lords, their allegation is that it is the property. That, Lords, in that event, Lords, they can show those properties to the assets, Lords. They can say that your sale proceeds, they can show it otherwise, Lords.
Yes, yes, Mr. Mohan.
And one more point, Lords.
If those properties are taken out, sir, if you either you take the sale proceed as an income or the asset as an income, he says that the assets were sold up. So the sale proceeds of that asset can be taken into consideration. Have you taken into consideration the sale proceeds?
Documents originally self-proceed has to file. Reliance has not filed that document. So he has to.
And in that event, Lords, of course, I have not filed that, but it's a public document. I can file those, Lords.
You can't go document, then you have a case.
Yes, Lords.
Then you have a case. You can take out those properties.
Yes.
If you take out those properties, it will come down below 100%.
And one more point, Lords. If the house is not standing, when the father is not taken out of the scope of this investigation, then Lords, the affixers and the assets
that is again a corollary to that. Once the house goes and everything goes.
Yes. Yes, that is
everything related to that house. But if you sold up that house, and that sale proceeds will be taken into consideration.
No, not house, Lords. It is landed property. House stands in the name of the father.
Yes.
So house, there is no quarrel about that because there is no challenge or order of the son court, Lords.
Yes.
Then their submission it was deleted.
Yes. I don't dispute.
Then second they now they are talking of the furnitures and fixtures, whatever they are, it should be deleted. The petition was residing there. And in the Caesar is put his signature, admitting that this belongs to him. So it is a matter of trial. So when other aspect is concerned, document, public document, it should be seen.
Do please.
I'll find those documents. So also you said that.
When can you file?
But 10 days time you also got me, I can file that document. 10 days time, I can file those documents.
Okay, within 10 days, at least the matter after 2 weeks, the counsel for the petitioner is granted liberty to file. Shall I record that you have, Mr. Samantra, and counsel for the petitioner submits that he would be filing additional document to substantiate his case. He may do so within a week, and least the matter after 2 weeks. Yes.
Within 10 days, you lost.
Within 10 days. Okay. If you can satisfy, then you have a case.
Yes, but that is the only one. If you come down to less than 100%,
then you have
that's circular.
I have filed this petition to Lordship for the casting of charge sheet. Your Lordship petitioner number 1 and opposite party number 2 married on the 5/23 and they are separated on 9/23. After that, the opposite party number 2 continued and the affair on the 13/24 and in the affair specifically she accused that the petitioner was torturing her and had some extramarital affairs. But in page 29 of the charge sheet, or page 29 of the petition, it is clearly mentioned by the investigating authority. I'm just reading it. I have collected
304 part 2 of the IPC. So other offences I have no. There is no material to take cognizance under that section. We will also kindly see the FIR. The FIR registered under section 279, 337, 304.
Yes.
And the police during course of investigation also found that prepare the inquest report opined that cause of death of the deceased reportedly due to accident. There is the accident, my lord. The petition
For 304 part 2.
304 my lord, not part A, my lord, 304A. In place of 304A, my lord, is my lord, written 2, my lord. Will also kindly see the
But it is 304 part 2.
my lord, 304A, my lord, there is a provision, my lord, for that, my lord.
So what do you want?
I want, my lord, that in place of that, my lord, if 304 part A, my lord, I have.
You argue about this at the time of charges. I can't change the
Absolutely no material, my lord.
framing of charges.
My lord, I will go there, my lord. Definitely there is some calling taken. Yes, my lord. Can you see for a moment 304?
It is 304 capital A or 304 part 2 has to be looked into by the court when framing charges.
My lord,
On the basis of material.
my lord, if on the basis of the no material, my lord, the cognizance taken by the magistrate, my lord, you will also have the power to proceed. That's right. And also director. But you, I have no.
What you say? You are saying that it should have been 304 A. You argue that at the time of framing of charges. Who stops you?
My lord,
Record it and they are.
on the prima facie case, will also see whether on the prima facie case will be met or not. Prima facie case is met under 304 part 2. There is accident, my lord. All there is accident.
Has set up I agree that prisoner has challenged the order dated 30th April 2024 passed by Leonard JMFC Purushothampur in GR case number 63 of 2024 whereby cognizance for offences punishable under section 279 337. Where is the cognizance order?
Page 25, my lord. Annexure 3, page 25.
And 337 304 part 2 IPC has been taken against the petitioner. Mr. Das, learned counsel for the petitioner, submits that even if the version of the investigating prosecution has reflected in the charge sheet is accepted at its face value, no offence under section 304 part 2 IPC is made out. Rather, it could be at best a case under section 304 part A. I am not inclined to entertain this petition at this stage for cognizance. However, liberty is granted to the petitioner to urge this point at the time of framing of charges. If such point is taken up by the trial by the petitioner at the time of framing of charges, the trial court is directed to deal with the same specifically and pass a reason order.
My lord, it will be delayed, and the problem is, my lord, the claimant will not entitle any amount as compensation. That is the problem, my lord. Unless the
specific speaking order has to be passed.
My lord.
Yes. Yes. 21 disposal.
Here in this case, my lord, cognizance was taken 341, 294, 324, 506, 34 and 3 of the SCST Act.
Yes.
The allegation is that, my lord, while the informant went to the shop of the one Debraj Maharana, my lord, there is a push and pull. There is a sort of exchange of word. Thereafter, it is alleged that they abused. Without proper investigation, my lord, charge sheet submitted adding 3 SCST 506. Only there is a push and pull. I made the informant as party, my lord. Let notice, my lord, issued.
Show me the charge sheet.
Charge sheet, my lord, cognizance was taken, my lord. I filed the cognizance annexure.
No, charge sheet, show me the charge sheet.
Charge sheet with me, my lord. That has not been filed with.
The charge sheet is only for your reference, not for the reference of the
Set up lateral I have received, that's why I could not file.
additional document.
Yes, sir.
Additional document after 3 weeks.
Next week, your lordship will see.
These are the minimum things. You are challenging cognizance order. You don't file a charge. And you are taking court's time.
No, here, my lord, NBW has been issued. Let him appear before the court.
You go appear and
Yes, sir.
raise all the points. That is a
Yes.
better idea.
Yes.
Item
21.
21. Petitioner is agreed by the order dated 24/7/2024, passed by the special, passed by the learned additional sessions judge cum special judge Nagar in special GR case number 35 of 2024, bracket SC and ST, SC, ST, whereby the court below has taken cognizance of offences punishable under section 18 phase 12, so and so. While taking cognizance of offences, the learned court below has also issued NBW against the petitioner. The counsel for the petitioner submits that the NBW issued against the petitioner may be quashed and liberty may be granted to the petitioner to appear before the court and raise all the points as has been pointed out in this petition. Apart from besides other points, regard being head to the submission made at the bar, I'm inclined to quash the order of NBW issued by the court below, subject to the petitioner appearing surrendering before the court on or before 30th of November or so and so, and resort to the remedy available to him under law. With this observation, the petition is disposed of. Yes.
Okay.
22.
Here in this case, my lord, I have also challenged the cognizance order. Your lordship can turn to page 11, my lord.
Yes.
Here, the informant is not a SC/ST person, my lord. Allegation is that, my lord, while there is a push and pull, my lord, your lordship, page 11, your lordship can see.
11.
Page 11.
Yes.
Toward last, my lord. ସେମାନେ ମିଳିତ ଭାବେ ବିଦ୍ୟାଧର ଭୂୟାଙ୍କୁ ତଣ୍ଟି ଚିପି ମାରିଦେବା ପାଇଁ ଉଦ୍ୟମ କଲା ବେଳେ ସେ ବହୁତ କଷ୍ଟରେ ସେମାନଙ୍କ କବଳରୁ ଖସି ଆସିଲେ। ସେମାନେ ଆମ୍ଭମାନଙ୍କୁ ଜୀବନରେ ମାରିଦେବା ପାଇଁ ଧମକ ଦେଲେ। ଏହି ସମୟରେ ସଞ୍ଜୟ କୁମାର ସେଠୀ, he is another person, my lord. He is not ବୁଝାସୁଝା କରିବାକୁ ଆସିବାରୁ ସେମାନେ ସଞ୍ଜୟକୁ ଗାଳି କରି କହିଲେ so and so. He is not there, my lord. As per my instruction, I made a party, my lord. Let notice go, my lord. He will appear and say that he is not there.
What is the investigation?
Investigation, SC/ST has been added and
Where is the charge sheet again?
Just say it.
You are reading the FIR and attacking.
FIR, my lord, as per
I should believe the charge sheet or I should believe the oral statement of you on instruction? You tell me.
No, that is the FIR story, my lord. Sanjay Sethi,
FIR story maybe, but investigation has taken place. Who was there? Where Sanjay Sethi?
Let notice go, my lord. He will appear that
so granted. Without filing document, you will file any paper and then I will start researching on that. And I will start collecting documents from the other side to establish your case. What is this practice?
No, FIR shows my
Where is the charge sheet, you tell me?
charge sheet.
Since you are challenging the cognizance order, you should file the charge sheet. Otherwise, how will I know?
Let notice go.
No, no, I'll
do next to my lord. You will
but this is no practice.
it
How can you challenge the cognizance order without filing charge sheet? You tell me.
charge sheet take
Can it be possible?
Sorry, my lord.
Can it be imaginable?
Your lordship, keep it to next week, my lord. I'll file that and
People have taken
appear, my lord. My lord.
Only one day to say that, Pasi.
No, only to
Courts waiting to collect the document from the other side to substantiate your
My
case.
lord, no.
In your case, you have to satisfy the court.
yes, my lord.
Right on. That counsel for the petition seeks an adjournment to file additional document to substantiate his case. 2 weeks time is granted to file additional document. Please the matter out 2 weeks. Give a specific date so that he will file it. File it because online filing.
Yes, sir.
Yes.
23.
Yes, my lord. And in this case, my lord, offense is my lord 307
Yes.
to 54B, and other offenses are there. My lord, the accused and the petitioner hearing are amicable second war matter, my lord. War in order. And
What are the offenses?
offense, my lord, 307 and 354B, that's simple injury, my lord. So,
The petitioner submits that the parties have settled their dispute and settled the dispute. Although the charge sheet
Charge sheet has filed.
for offences punishable under section 307 IPC apart from other offences, but the injury sustained by the informant are simple in nature. Therefore, there is no legal impediment in quashing the FIR, quashing the criminal prosecution against the petitioner. Issue notice to opposite party number opposite party number is on advance notice so and so entered its appearance on behalf of opposite party number 2. Where are the parties?
Parties has not come, my lord.
All the parties. Please the matter after 1 week. Please the matter. All the parties. Yes.
24.
Shall I state?
Yes,
Number is there. Yes.
24.
Petitioner is the wife,
Yes.
but she filed a complaint case against the husband and the other in-laws under section 498-307.
Yes.
The cognizance was taken and the process was issued. And at the time of filing the complaint petition, the petitioner mentioned the address of the matrimonial house. So the summons were issued in that address. It was not sufficient. But kind of a glance, page 11, madam.
11.
In full order,
Yes.
in which manner the complaint petition has been dismissed due to non-filing of the fresh correct address, madam. Only I pray, my lord.
No, who are you? You are the
I am
complainant.
the complainant. Complainant is the wife. On page 11, I am reading the order. Complainant is absent. Law and counsel for the complainant is present. On perusal of the case record, it is found that several times notices was issued to the accused person to that address as mentioned in the complaint petition, but SR was back without sufficient service. Therefore, law and advocate for the complaint was directed to furnish correct correspondent address of the accused person, but after giving many opportunity to the law and advocate for the complainant, law and advocate for the complainant failed to furnish the correct correspondence address of the accused person. Therefore, this court don't think it proper to linger this case.
So what is the solution? If you don't give such address,
But that in fact the complainant was absent on that date, and the address which were available with the petitioner, the wife, matrimonial house address he has not given at the time of furnishing the filing of the complaint petition.
you have fresh address or not?
Yes, ma'am. I am praying your lordship may give remand to the matter and give me 1 month time. In the meantime, I will give the correct address.
Why 1 month? If you have, you can file immediately.
Yes, ma'am. Your lordship give some time.
Petition is agreed by the order dated 12/2/2024, whereby it is her complaint. You are the wife,
Wife.
her complaint against the private opposite parties have been dismissed on the ground that the petitioner could not supply the fresh addresses of the private opposite parties, namely the accused, alleged accused persons. Learned counsel for the petitioner submits that on the day when the impugn order was passed, in fact, the complainant was absent, and the learned counsel for the complainant could not furnish the fresh addresses of the accused persons. Therefore, the court below, and therefore the learned JMFC DMFC?
Daringabadi.
Huh?
Daringabadi.
Daringabadi has passed the following order, page 11, following order. Next, Mr. Dividi and counsel for the petitioner further submits that if the matter is remanded back and restored to the original file, he would make sure that the press addresses of all the accused persons are furnished within 15 days from the date, within 15 days. Within days. Regarding to the submission made at the bar, the impugn order dated 12/2/2024 is satisfied. The complaint ICC case number 9 of 2021 is restored to its original file, subject to the petitioner furnishing fresh addresses of all the alleged accused persons in the complaint case. With this observation, the petition is allowed. Yes.
15 days from the production of the certificate.
Yes, certificate. 15 days from the production of the certificate copy of this order. Yes. Yes.
25.
Yes, sir.
I have not received the required instruction. Let it come along with the 3330 of 2022.
What is that matter?
That was the petition filed same petition for challenging the passing of proceeding.
He has filed.
Ma'am.
Your worship, can see order dated 11/9/24.
Yes. What happened to that writ petition?
Still subsists.
Still there.
Pending.
Then it is to be decided first.
Let us wait till the outcome of the writ petition. Because the Lokayukt report, which was made the basis of registration of this case, is under challenge in that writ petition. Unless that writ court decides something this way or that way, we can't take the call.
I don't know the reasons.
I came across this kind of another matter, I think, or this matter. I don't.
Let it come along with 3330 of 2022. So
that I'll pass the order.
In that case,
But we have to wait till the outcome.
the thing is, then in that case also the Lokayukta proceeding was under challenge. The action of the Lokayukta was under challenge, and this honorable court is not inclined.
That was a different.
Okay, leave the matter along with Gibbs also. After 3 weeks, the interim order passed on 11/9/2024 shall continue till then.
26.
I don't 26 and 27 you also kindly pass.
That's one thing, my lord. That in that case, my lord senior perhaps has inadvertently perhaps the earlier case certificate has not been given to correct correction.
I'll give it now. Yes.
Pass it over.
Pass over.
Yes.
Okay.
26 and 27.
Yes.
Okay.
What time? 2 o'clock or after 12? Just I'll come and take it up. Okay. I'll just come and take it up.
Petitioner here has challenged the order passed by the additional sessions Contavanchi under Annex 3, my administrative page 53.
Yes.
Order dated 28/2/2024.
Yes.
Just before going to the order, madam, I want to draw my lord's attention to the affair under Annexure 1 at page 14, madam.
By this impure order, how are you agreeing?
It will not be clear, madam, from the impugn order.
Okay.
Why?
FIR.
It is why, madam, yes.
Yes.
Madam, under Annexure 1, case was registered against the petitioner for offences punishable under sections 420, 468, 469, 472, 475, 487, 270, 274 by 34. Read with madam, Trade and Mercantile Act, Copyright Act, so on. Madam, here the investigation has been completed, the sheet has been submitted, cognizance has also been taken, and the course has been committed. But for the same occurrence, but around 10 complaint cases have been filed for the same occurrence, same day seizure, because the allegation is the petitioner was producing spurious medicines, this, that, many things. But I'm not challenging the same on merit. For the same seizure, around 8 to 10 cases have been initiated. The nature of complaint, madam, at least one case may be seen. Page 26.
Yes.
Any one case. Here, Baradu C. Lalit Sahu is dog inspector, page 26, madam. It is complaint case number 209. Lalit Sahu, accused is Sankar Agarwal.
Yes.
Witnesses.
Violation all the witnesses are there. Yes.
Violation of section 18
days. Date and time of sampling is 23/7/2007.
Malad sampling. Finally, sampling taboo case covered. Similarly, Malad may see next annexure, that is at page 30.
Yes.
Sorry, page 31.
Yes.
Lalit Sahu, again, Malad 18C, 18 to so and so.
Yes, okay. Okay. Yes.
Malad cases have been.
Likewise, 8 cases were registered. Yes.
I draw the attention of the Lawrence Addison Session Court in the ST case, but that all the cases which are pending before the magistrate may be brought together to be tried as one case, talked together along with the session.
Including that FIR.
In FIR is pending with Addison Session Judge in ST number.
So you wanted that the complaint case should also go there.
That, yes. There should not be any.
What was the trial court says?
Madam, let's see. It is amply submitted, Madam, we see in the allowing counsel, but the accused persons are present. The accused persons are found to be absent but allowed to be represented. Petition filed by the allowing counsel for the accused, namely Sankar Agarwal, under section 210 of the code is taken up for hearing.
Yes.
Copy shot of the special BP is submitted by the allowing counsel that 11 of number of cases arises out of the same incident of which the instant case is one. Except this case, other cases are pending in the court of General FC Contavancy. As such, those cases be called for and cropped out in a order to have fair and just adjudication of the case. On the other hand, the special BP vehemently objected. The submission and submitted internally.
He only says that it has not been committed.
Yeah.
What do you say?
The last question having now the both the parties going through the contents of the petition filing comment comes in, but we have taken on the contents of it. We found that the
Case numbers have been mentioned.
And thereafter it says that it has not been committed, so therefore I will not tag.
Only this one.
This is of that they have the
Magistrate can do so under section 323. Long back ballot in the year 2002, I have raised this point.
210 also just see, 210 and
210 subsection 2 is clear.
subsection 2.
Bereft of that,
If a report is made by the investigating police officer in concern, such report is submitted taken by the magistrate, by against any person who is accused, magistrates are both the cases that issue. Yes. You respond to it. Response to it. Yes. And only I am giving one. See, there are two other practical problems. Practical problem is why should the trial court be burdened with so many cases?
unless it is
Tagged together And he is to be convicted, no problem.
Yes.
It is only what he sees is all the cases should be clubbed together. That's all. And that is only for there is no legal bar. Rather the procedure supports his contention. And you check it up. To take it up, you will get it.
Two is very clear.
You check it up and tell me. Next week, let it be on 14th. 14th. So that we will allow and let the trial go on one court. Okay. Okay. Yes.
31. Only when I pray for stay of the
No application. Mr. Dhal, counsel for the petition submits that if the matter would be taken up in between, he may move an application for seeking an adjournment before the trial court if such application to the same subject. Yes.
31.
Yes, sir.
Person has filed this case in the order of cognizance against the passing of the entire criminal proceeding matter.
Yeah.
The petitioner is a transport agent. And the transport agent at that point of time in the year 2014. And FIR has been lodged relating to shortage of quintal 500 of S&P rice matter.
You are agreed by the order taking cognizance.
Yet in the agreement,
Where is the charge sheet from?
my charge sheet is there, it is there, but I am not annexed my.
You file it.
My only I pray,
No, you file it without charge sheet.
what I am saying that in the agreement, it has been categorically stated this security amount is there, the collector is the authority.
I don't know whether in the charge sheet these things are taken into consideration or not.
Only I pray, I may be allowed to file a fresh application before the court below by agitating this text relating to the agreement or other conditions. He may be considered it till that charge.
This is 32, no?
31.
31, yes. Mr. Vishwal and counsel for the petitioner submits that he would be submits that he would not press this petition, rather prefer to agitate all these points. Which,
the agreement or others?
all these, you have taken this point, all the point, relying upon the copy of agreement
And payment of the
agreement dated
dated for the year 2013-14 minor. Annexed of-
2000 agreement which has been filed as annexure 2 to the petition, and the letter dated 14/5/2019 which has been annexed as annexure 3 to this petition.
All the funds relying upon the copy of the agreement
Before the court below at appropriate stage, if appropriate stage, the petition is disposed of with the liberty to the petitioner to raise all these points on the basis of, on the strength of the annexure enclosed with the present petition, by filing the appropriate application before the court below. If such application moves, the same shall be considered and a speaking order shall be passed. Yes.
So
May please, Your Lords. May please, Your Lords. Lords, if the matter is
Wait, because the parties are there, 28 and 30, 1 minute.
32.
Huh?
32 that is settled between.
1 minute, he is also sailing in the same boat. Yes, 32, huh?
Yes, Your Lord.
Yes.
I'm submitting, Your Lords, if the joint.
What are the offences, sir?
Offense, Your Lord, section 376 2 and POCSO Act is there, Your Lordship. And last again, Your Lordship.
22/2/2024 for taking cognizance on the section 498, 341, 294, 323, 330.
Yes.
534 IBC, my lord.
Yes.
Petitioner is a husband. So, for 330 concern, my lord, the petitioner is no connected in this case. As per my the medical report submitted,
What is happening in the marital life?
living separately.
Have you filed, initiated any proceeding, divorce, anything?
No, madam. No, madam.
She is not also initiated.
No, madam.
I just issue notice because it is family matter. Issue notice, huh? Written notice. You sir,
Once warrant has been issued, my lord. Well,
where is that? 32 item? 33.
33.
Where is that?
Annexed 3, my lord.
In the meantime, the operation of order dated
2/24.
13/2/24 issuing NBW against the petitioner shall remain stay. Yes.
Obliged.
Yes. 34. Execution of NBW shall remain stay. But if you don't and you don't file a requisite by tomorrow, this interim order will be vacated automatically. Everywhere you write like that. What happens is taking a stay order, then don't file the requisites for years together. This is happening, so therefore I am writing that. Yes.
The petitioner is the son and informant. Opinion number
34. Okay.
Mother, opinion number 2 is the mother of the petitioner. There was a disturbance between son and the mother. 294/506 is the.
Yes.
My lord, I am appealing.
In the meantime, the matter was settled between the.
My lord.
Where are they?
My lord, today separate day. They are residing only 5 kilometers from this court. So that they will come.
Why they didn't come today?
My lord, I was not included list of.
Or you want that the court should
Fix up a date so that.
court should print an invitation and send them.
No, my lord. I think only state that.
Why are you wasting court time like this? If the matter is settled, you call them and call it.
My lord,
Why would they ever call at 3 o'clock?
my lord,
5 kilometers they can come. They can walk down. 5 kilometers what is
poor persons they are going to.
so let them come and pass it. Why do you trouble them once again? You can come
Tomorrow, fix up tomorrow.
tomorrow. Call them. A small matter I am is pending.
Cesar Abdul, Kalias.
Paperless.
Tomorrow. Call them. Page it up. Yes.
35. That is matrimonial offense. There was a proposal for marriage by the daughter of the informant with the petitioner one. And the ring ceremony held. And the case of the petition like this, at the time of ring ceremony.
Who are you? Who are you?
I am the proposed son-in-law. There is a proposal for giving marriage for the ring ceremony. And the
Proposal of marriage between petitioner number 1 and
but the case is that at the time ring ceremony, the informant is given 2,20,000 and subsequently found that the petitioner was married twice. So she is reluctant to give marriage on that time. The demand a refund of her amount. So out of that, 1,10,000 has refunded by the father of the petitioner 2, and the rest are not refunded.
You had taken 2 lakhs.
As per his story,
Whatever. How much you have taken? Tell me.
in the meantime, 1,10,000 has given before the trial.
That means you have taken something. Therefore, you have given.
Only in order to save the service they have given. Actually, I have not taken my plan.
How much you have taken? You tell me. I'll say it subject to depositing that.
Yes, no.
You are not married.
No.
At the negotiation stage only you have started asking money.
Yes, I have given the informant given affidavit, and the rest amount 1,10,000 he will take position of the court at the time of passing. He has given affidavit to the.
You deposit subject to issue notice to opposite party number 2. Subject the further proceeding in so and so is stayed. Subject to petitioner depositing how much?
1,10,000.
1,10,000 rupees before this court.
Yes.
Yes.
Next day, will come.
Yes, you bring. I'll give it and cost it.
Date may be given.
Date will be given.
Yes.
After 1 week.
Yes, ma'am. Okay.
Yes. The deposit, huh? Come more.
36 days to get report. Because my client will come in front of our own.
Yes. So then now 18th. Yes.
Petitioner earlier got the anticipatory bail, that is the page 13, but he could not avail.
36. Yes.
Yes. That is the annex to page 13. Petitioner earlier got the anticipatory bail. Thereafter, charge sheet filed and cognizance taken and summon issued the petitioner. I am ready to appear the court, but one thing, since offence is the 307 IPC, so he cannot grant the bail. So directly,
I see. What is the order?
The annex to 13, page 13, my friend.
He shall be released on bail.
Yes, my lord, shall.
But petitioner had earlier approached this court by filing ABPL number 1079 of 2020 by the order dated 10/2/2022. The coordinate bench of this court passed the following order, para 3, following order. learned counsel for the petitioner submits that for certain reasons the petitioner could not avail the benefit of this order. Meanwhile, the charge sheet has been filed and cognizance has been taken. He has now assailed the order dated 17/3/2020. Where is that?
Page 14.
Huh?
Page 14, my lord.
14.
14.
Whereby the cognizance is taken.
Yes, cognizance is taken. Offenders of 341, 294, 323.
What happened in this order?
Annex 3, page 14.
Where is the NBW? There is no NBW.
No NBW. Issue summon to the petitioner.
All right. Whereby the learned court, trial court has taken learned HCGM. What is that? HCGM? Bhanjanagar.
Yes.
Has taken cognizance of offences punishable under section 341, 294, 323, 307 and 34 IPC and issued summons to the petitioner. Learned counsel for the petitioner submits that he would not press the present petition challenging the cognizance order. However, liberty may be given to him to avail the benefit of the order dated 10/2/2022 passed by the coordinate bench in ABPL number 1079 of 2020. Regarding head to the submission made at the bar, the present petition, although is dismissed, but liberty is granted to the petitioner to appear before the court below and court below on or before 15th of November so and so and avail the benefit of the order dated 10/2/2022 passed by the coordinate bench in ABPL number 1079 of 2020.
Yes. Obliged.
37.
Petitioner challenging the order dated 25/9/24 in releasing of his vehicle. The condition was imposed. Condition number 10 and 11.
Where is that?
Page number 15.
Page
15.
Yes.
That in this regard,
What are the condition?
condition was he has to file an indemnity bond of rupees 65,000 with one property surety, and condition number 11 is petitioner shall find pay sum of rupees 88,800 to Binapani Jubok Sangha for maintenance of the car. Lord, in this regard, Lordship has passed similar order. I have annexed that.
Where is that?
That annexure 2, my lord, page number 17.
Yes. What is that order? It is impossible for the client to also. I'm sure that even extend that yes, what do you want? Similar means what? This is 1,50,000 there in that case.
As for this ratio, the order will work.
Say how much you will deposit, how much what is the total amount directed to be deposited?
Deposit
Petitioner property 88,800.
45,000.
Which part you want variation?
That amount part. Indemnity bond will work.
Individual, but amount who will take care of where the cattle are there?
At the Binapani Jubok Sangha toward expense.
What will be the expenses?
They are not providing any.
The statute, the rule says that 200 rupees per day.
There is no certain approximate amount that 200 is spending toward that cow. That's why that is the problem.
But something you have to deposit, otherwise how they huh?
I'll deposit 45,000.
No. See, how many, what is the number of cattle seized?
13 or 11 numbers of
Huh?
13 or 11 numbers of cattle.
13. You just tell me how many cattle you have seized. 13. 13 cattle, they are there. Therefore, at least 75,000 rupees you pay.
Very much, 60,000.
Where from this sum will get the money to, for bear the expenses?
Individuals who are giving charity to for the maintenance. That's but
No, I don't know whether it is a NGO or what is this. Bina Pani Reproduction. It may be association. I don't know what is the source. You know appropriate application before trial.
rest of the amount they will pay in indemnity bond.
Huh?
50,000.
Like 65,000 rupees indemnity bond in any case you give, and out of 88,800
will pay for the maintenance.
to begin with. Thereafter you move application. Right. Alert counsel for the petitioner is agreed by the condition imposed by the learned is JMFCJ.
JMFC.
Where is that?
JMFC Joseph.
Mayurvanj. Mayurvanj in CMC by the order dated 25/9/2024 in CMC number 30 of 2024, whereby the petitioner has been directed to deposit 88,800 with one Bina Pani Jubak Sangh towards the expenditure of maintenance, for maintenance of 3 cows. 3 cows and only 3 cows. 3 cows, and the petitioner shall also submit 3 cows. The counsel for the petitioner has relied upon the order dated 29/1/2024 passed by this court in CRLMC number 3539 of 2023, whereby this court had modified the amount directed to be deposited in that case. The operating part of the order reads as under para 4 of that order. Please under. C seeks indulgence of the court and praise for the similar order. I have perused the opinion order and documents please before this court. Mr. Mr. Vishwal, counsel for the state, submits that under the Prevention of Cruelty to Animal Act 1960, the release of the vehicle is always conditional in nature, and it should commensurate with the expenditure to be caused for keeping the cattle seized. Therefore, there is no infirmity in the impugn order. Here is the impugn order and relevant document. Please before the court, before this court in the present petition. I'm up for the considered review that the petitioner, the condition imposed by the trial court for depositing of 88,800 is liable to be varied, and accordingly the petitioner is directed to deposit 50,000 rupees with Vinapani Jubok Sangh for the purpose of bearing expenditure for maintaining the seized cattle. Seized cattle.
6 number of 6 number.
3 para 11 it is 3.
6 number.
Seized cattle. Seized cattle. Seized cattle. Yeah. Seized cattle. With this modification, the petition is disposed of. Yes.
38. The order of cognizance under section 493, 323, 294 506, 406 and 34. They are telling on the ground that in the meantime, the marriage between the parties are dissolved by decree of divorce. Let's kindly have a glance to this number.
Okay, issue notice to the opposite party number 2 returnable so and so. In the level counsel for the petitioner submits that in the meantime, the marriage between the petitioner number 1, and opposite party number 2 has already been dissolved, and there is a settlement.
This matter
And in view of the settlement arrived between the parties, regarding head to the said statement, the further proceedings in so and so case is state, release the matter after 2 weeks. Yes.
One appellant is there and item 67, another appellant is there. Both arises out of the same TR. Your lordship has already called for the TCR and CRL number 1001 of 2024.
Release the matter along with
1001 of 2024.
Yes.
And here in this matter appeal, only the stay realization file petition has been filed, no application for bail. Your lordship may kindly have a glance.
it's all right. I'll bail granted.
Bail petition has not filed.
Yeah, it's why unnecessary small technical. She will move another application. Again, one matter will be
Passing the
forget about I am granting bail without application. Whole prayer.
Filing application for
Sentence.
prayer. 3 years.
All right.
Prayer portion is there only.
Bail granted, realization of fine is stayed, and call for TRC and tag book soon.
Your Lordship,
67 is the same.
67 also same.
67, another prayer by my learned friend is there to dispense with the judgment copy.
Your Lordship,
Judgment copy dispense for the
filing the judgment copy that may be not pressed, Your Lordship.
not this.
I
But you are right there, na? No, it is there.
Counter set. Filing counter.
Filing the counter. She submits that she is liberty granted to the petitioner to file the certified copy of the impugn order during the course of the day. During the course of the day. The application for exemption is become infectious.
IFS bill has been filed, Your Lordship.
All right, that benefit of doubt is given to you.
67, this is the item
And
67.
Mr. Sanjay Mishra, both 39 and 67 over. Yes.
40.
There's a fresh appeal matter.
Yes, I will 4 years.
4 years.
4 years.
Okay. See,
Understood.
same.
Release
Release on bail, and yes, they have realized. Yes.
Free copy. Free appeals modified.
Copies. Okay.
No. Free copy.
Acha, free copy of-
6 order.
Free copy of- Yes.
And name may be replied.
Urgent certified copy. Custody.
Today only you will get it. I understand. You are in custody. You will get it. You have your body, huh? See, custody also there.
Highly blessed.
Yes.
Okay.
May I please, my lord? The petitioner filed discharge petition before the Lord Special Judge Vigilance, and it was rejected against that order of the petitioner. The sole ground of the petition is that the petitioner was the record keeper. The RI is to give mutation certificate, but the no work was pending before the Lord Special Judge, and the Lord Special Judge rejected my discharge petition.
Maybe passed over my lord, Mr. Das is someone.
Pass over. Yes.
Pass over.
42.
42.
Yes. And again, this is the case assailing the rejection of discharge petition by the Special Judge Vigilance, Deccan Madam. That's the carry turn to page 15. 15. 15. Yes. There is the order of rejection. Yes. Yes. Her question is that while I was coming from my home and I was auditor, in 2012, when I was coming from my home along with another auditor and peer, the vigilance authority cut around 1,14,000 from my. There is no check period. That your lordship previously had approached the lordship implied is directed that expressly directed, you go and approach the, maybe a good case which approach the, yes, for the discharge of the proceeding. Let's see, can you turn to page 50? Yes. Okay, this order arises out of petition and second paragraph of the deed. No, notice has been issued. No notice has been issued. Yes. Yes. But paragraph 2. Paragraph 2. Yes, paragraph 2 is 1 5. Yes. The warrant counsel for prosecution opened the case of the prosecution and submitted the recovery of such huge amount from the person's possession of the accused deed itself represented to raise.
Pass over, Mr. Das.
Yes. I may not be available after I have some personal difficulties. Tomorrow? Next week. Yes. Next week. Yes. Next 43. 14 charge date is fixed. Therefore, I am saying date it tomorrow or the after. No, I'm putting it on 11th. All right. 11th.
43.
12th. 11th PC, you know? 13th.
Can I answer this one?
Huh?
Can I answer this one?
Mediation.
No, man.
Why urgent? ठीक है. Urgent.
44.
Belgium Matrimonial or NBW issue on 3/4/2024. Today he is on bail on 22/3/17.
Probably. Oh, 500. Yes.
45.
Lordship, on behalf of Prasanna Kumar Sen, my lord, Belgium Matrimonial, earlier bail was granted on 1/6/2022, my lord, and NBW was issued on 27/2024, my lord.
500.
46.
46, my lord. Belgium matter, my lord, NBW has been issued on dated 5/9/2023. Earlier he was on bail, which I have annexed and as annexure to at running page 11 by this honorable court by the order dated 14/10/2020. He was on bail and he has
500.
47.
Belgium matter. Earlier petitioner was on bail by the annexure 1 on dated 24/6/2016 and NBW issued on 22/7/2024.
500.
Mal.
58.
Lordship only 7. Lordship will direct is cessing over the matter because he is
about the matter.
Mal.
Yes. 48.
Belgium matter, my lord, NBW issue, my lord.
2016.
Yes, my lord.
Yes.
23/9/2016.
You are on bail.
Yes, my lord. 23/9/2016.
23/9/2016.
2016.
That is the NBW issued.
16.
You were on bail or not?
That I'll take instruction on that.
On bail list you 2016.
16.
UP 1.
Lordship, at para 3, your lordship may have a glance.
Para 3.
My lord.
Yes. He is not written whether he was on bail or what.
My lord. Only he was not aware of that, subsequently.
तो ये मैं मेरा bail will लिख मत लिखना. Para 3 जो लिखा है लिख लो para 3. He was not aware. He received he got the information regarding the issuance of NBW dated 23/9/2016, and you have not written when he came to know nothing. What kind of petitions are we filed? 1,000. At least you should have 2016 the NBW issued. You have written that I was not aware. At least one sentence you should have written, I came to know recently or something. We need to be taught like these things. This is not CRPC, nothing. These are minimum things. You should write when you came to know. Well, 2016 until today you have not approached this court. Why? How are you explaining? You not explain. 1,000 cost code. The problem is if you dismiss it, again it will remain like that only.
My lord.
That's the another problem. But don't file you are a young man, don't file the petition so casually. It is not, when any petition you file, it will be allowed, not like that. Suppose I'll dismiss it, then? Yes, 40?
49. She is 17% file, it was rejected on 2/1/2024. And
Somebody else is also.
misconduct.
Okay, okay. What happened?
She is 17% file on 2/1/2024 and rejected and imbue issue.
Okay. Petition, by the order dated 2/1/2024.
24.
No.
4113.
For 113.
Your 317 was,
Rejected.
okay. Now, where is that, what is the special petition?
First.
What is this?
2024. Order dated 2/1/2024.
What is the special petition?
317 will also be.
No, there is a special petition reference is there. The honorable, and it is pertinent to mention that on the bail application of the accused person is something to go to the trial court. No, where is that special petition order?
Lordship, I do not have any.
Whether it time bound fixed by the,
Yes, sir. Time fixed.
where is that?
See, time is appear करता है लिखा है जी, that is written also. Because sheet metal that has been written in sheet metal.
Yes.
Allow her to represent the accused for today only on the ground that the accused is cheat. Order dated 2/1/2024.
Now, what is the order of the Supreme Court? The person has been falsely implicated and however shown so trial court is ready to insofar the consideration of bail, we are of the opinion that the fact that we are not willing to grant bail injection. However, taking into consideration the trial in progress, it will be directly trial court to expeditiously, needless to mention that if the trial is not concluded within a period of 6 months, the petitioner at the liberty to inform. Time bound, there is no time bound given. No. Petitioner is agreed by the order dated 2/1/2024, whereby the NBW has been issued against him. Mr. Maharaja, Land Counsel for the petitioner, submits that he moved an application under section 370 CRPC to appear before the court through the counsel as the accused was sick. However, the said application was turned down and NBW has been issued. On instruction from his client, he submits that his client would be appearing before the court on or before 30th of September, November, and it's up to the remedy available to him under law. Taking into consideration the facts of the present case and the statement at the bar made by Mr. Maharaja and counsel for the petitioner, the NBW issued by the impugn order dated 2/1/2024 is set aside, subject to petitioner paying a cost of rupees 500 to the District Bar Association. District Bar Association. Which district is this? Koraput, District Bar Association, and surrendering before the court as per the undertaking. Yes. Yes.
You'll also make any mention on behalf of BB.
On behalf of
Maharaj on behalf of.
yes.
50.
Please, your lordship.
Yes.
Here I've challenged the issuance of bailable warrants against me. So also an application for appearance through virtual mode, which has been simultaneously rejected by an annexure 1. I draw my lord's attention to page 2 of the legible copy of annexure 1.
Yes.
I find the legible copy.
Now, what is this offense?
Lords, the offense are under section 341
and other allied offences, where I was granted anticipatory bail by this honorable court, and pursuant to which my bail I had appeared, and the case was pending before the learned court below. If your lordship will kindly have page 2 of the annexure 1, I'll just draw my lord's attention. Another accused, namely Kailash Acharya, who is the petitioner, is absent. Service report of the notice issued against the accused person is not back. In spite of the service report being not back, accused, namely Kailash Acharya, is absent on repeated counts and I'll pass it without appreciating the fact that I am now what is you need. Consequently, a virtual court, I had applied for an application for appealance through virtual court. Where is that? That application is that application has been dealt. If your lordship will see, order dated 17/9/2024, page 3, legible copy. Internal page 3. You will not accept that order? Yes, my lords. That is a part of annexure 1, my lords. Part of the annexure 1. Okay. I have 5 legible copies, typed copies. Lordship may kindly have a glance. This order arises out of a petition filed by the learned counsel for the accused, namely Kailash Acharya, praying therein to allow him to appear through virtual mode at the time of commitment. Copies served on the learned APP. Only at the time of commitment. Yes, my lords. For the tenor of objection, it is understood that the learned APP has no serious objection to the present petitioner. Heard the petition and the case record, it would be befitting to mention here that this court is not equipped with virtual court facilities. Then, hence, without everything, what to do? It's the very fact that very fact, whatever. If the court doesn't have, then everything will be solved. All the district courts have been. This court doesn't have. What to do? He can at least appreciate the fact that the petition appreciated. He said that I have no problem, but the only problem is if I don't have a computer, what can I do? Likewise, for the accused, then if I pass this order, allow your application, then I will have to supply the. This is a case where your lordship can supply the computer. Strict rules with regards to video conferencing facility, which can be very infrastructural problem. The court doesn't have a computer and all. Now, can I tell you? No minutes. Now, each and every court is. This court doesn't have. That is an administrative side problem. The district courts are well equipped. The district courts are well equipped. If you are do you need to have a debate on this? What I am emphasizing here, is the fact that petitioner is partially blind, I understand everything, but if the court doesn't have the facility, can the facility court some salary will do it or what? At least adequate grievance of the petitioner can be addressed with the fact that if the court would have taken an initiative, because nowadays either we could have consulted the district courts, and how do you know he has done or not? He has simply rejected without anything. All these things will not reflect in the order. In the administrative side, we are taking all actions. We are trying that all the courts are equipped. Unfortunately, this court, there are not many issues. In fact, there are no infrastructure, there is no so many things. Everything is written here. What is happening is office. Yeah, so this conversation with the fact that now in fact petitioner 1 minute. Petitioner is agreed by the order dated 3/2024, whereby bailable have been issued against him. He is also agreed by order dated 17/9/2024, whereby his prayer to allow him to appear through virtual mode has been rejected. Mr. Pandal and counsel for the petitioner submits that the second prayer made by him has been rejected, despite the fact that learned APP had no objection to the same. No objection to them. I have perused the order dated 17/9/2024. The learned trial called learned JMFC, which is that place? JMFC H. Hatyadi. Hatyadi. Has in the district of did not accede to the prayer made by the
petitioner only on the ground that the court is not yet equipped for entertaining the prayer for virtual appearance of the petitioner. I see no reason to interfere in the said order. Therefore, the second prayer is rejected at the stage, rejected at the stage. However, liberty is granted to the petitioner to renew the prayer before the trial court. Before the trial court. I will supply a computer. My predicament. Wait. The first prayer of issuance of bailable warrant is concerned, the petitioner deserves merit in the case. So therefore, the bailable warrant issued against the petitioner is set aside. Subject to petitioner appearing before the court on or before 30th of November.
That is my sole predicament. If your lordship will bear with me, here I have
and resort to the remedy available to him under law.
the only problem with my lords is I am 84 years old. I am not capable of moving. My lords also. I am
Learned counsel for the petitioner. At this stage submits that the petitioner is
I have already
petitioner is about 84 years of age. 24 years and is partially blind. So therefore virtually impossible on his part to appear before the court physically. Taking into consideration the said fact, liberty is granted to the petitioner to move an application under section 205 CRPC before the trial court. If such application is due, the same shall be considered sympathetically, taking into consideration the age for the petitioner and the physical incapability the petitioner is suffering at this stage. But instead of supplying computer,
your lordship is right aware that in fact all the judicial officers have been given tablets and laptops.
Can't even afford it.
What is Millers? Your lordship has ample powers.
You have ample money. You why don't you give it?
Millers, I believe that will not be.
I won't be.
That won't be an answer to the
Same thing. We are taking every action in addition. Judicial intervention in these kind of petitions are not. These are the discussion of the honorable chief justice, and he is taking care of the infrastructure, and we are getting funds every now and then. We are having meeting. Taking stock of the situation in each court, what is happening. There are many issues. I don't know what exactly is happening in this court. So everything is being taken care of.
My predicament was since the district court was well equipped with the facilities, the magistrate could have taken a sympathetic.
I can't in the judicial order pass. But I'll just see. This is which area?
This is in the district of Keonjhar, JMFC Hatyadi, my lords.
Hattodi.
Hatyadi.
I just go. I'll just see.
But my approval still till that time may not be insisted. I'll
I have seen your age, 84 years. Partially blind, so 205 has to be allowed. 205 is not these kind of people.
I'm grateful. So therefore, in those circumstances, the JMFC could have also. And that was my predicament, my lords.
Okay. Now I've allowed everything. Okay.
Lordship, one humble prayer.
Yes.
Lordship, item number 49. That in the FIR, it was mentioned that the police had seized 2,850 plus kilo of ganja was seized, and this accused person was the main accused person in that case.
40?
Just prior to this item 49.
I have not granted bail. I have only asked him to appear and resort to the remedy under law.
That is just I brought to
Yes.
notice of the.
It gets to see the problem is he is absconding.
Right.
And because he is absconding, trial is stalled. Now I recorded his statement. He will go and appear and his trial will go on. What is wrong with it? He is not entered. He will be taken into custody. He will be taken into custody, obviously.
This item 52 needs to be tagged with another matter, so it can be merged.
You tell him.
That's right. Okay.
Yes.
Official of victim. And yes, emission of yes. And other are simple.
No, injury may be simple, but where is that 80?
It's not there. Yeah.
84, huh? No, 85 rather. No bleeding, so and so, no bleeding or injury. Yes. Yes. I think we are not ready. Get ready, get ready. I'll hear you after 2 weeks. Get ready, yes. You need the file home and come. You can't afford 2 weeks time. Tomorrow. Not tomorrow. It will come after 2 weeks, yes.
54. Lord, sir, case of 302 Milord, and the second journey after charge sheet Milord, and just at the last page 26. Custody since Milord 10/3/2024.
10/3/24.
Yes, Milord.
Okay.
Only just at the last page 26 Milord.
26.
Yes, Milord.
Yes.
May I read it, Milord?
Yes.
Who is the victim, man?
Who is the victim? And the occurrence is Milord, that is on 23/1/2024, but the FIR has lodged Milord 9/3/2024 Milord. Then Milord page 26. The Dejina Patra.
23 incident
is 23.
23 date 23 what?
23/1/2024.
Okay.
And the FIR is lodged Milord 9/3/2024.
Okay.
Then Milord page 26 Milord.
Yes. Read it.
ମୁଁ ଡେଜିନା ପାତ୍ର ମୁଁ 9 ବର୍ଷ ତଳେ କାଉଡ଼ିଆପଡ଼ା ଗୁଆଳି ଗ୍ରାମର ଦୀନବନ୍ଧୁ ପାତ୍ରକୁ ଭଲ ପାଇ ବାହା ହୋଇଥିଲି। ମୋର ଗୋଟେ 8 ବର୍ଷର ପୁଅ ଓ ଗୋଟେ ଝିଅ 1.5 ବର୍ଷର ଅଛି। ମତେ ମୋ ମା ଶାଶୁଘର ଲୋକ ସବୁବେଳେ ମୋ ବାପା ଘରୁ 2 ଲକ୍ଷ ଟଙ୍କା ଆଣିବା ପାଇଁ ବାଧ୍ୟ କରୁଥିଲେ। ମୋ ସହ ଝଗଡ଼ା କରୁଥିଲେ। ଗତ ତା 23/1/2024 ତାରିଖ ଦିନ 10ଟା 11ଟା ଭିତରେ ମୁଁ ଚୁଲିରେ ଭାତ ରାନ୍ଧୁଥିଲା ବେଳେ ମୋ ପଛପଟୁ ପିନ୍ଧା ଲୁଗାରେ ନିଆଁ ଲାଗି ଯାଇଥିଲା। ମୁଁ ସେଇ ସମୟରେ ନିଆଁକୁ ଦେଖି ଚିଲେଇବା ବେଳେ ମୋ ସ୍ୱାମୀ ଶ୍ୱଶୁର ଦେଢଶୁର ମୋ ବଡ ଯା ମୀରା ମୋ ପଛପଟେ ଠିଆ ହୋଇଥିଲେ, କିନ୍ତୁ ସେମାନେ ନିଆଁ ଲିଭେଇଲେ ନାହିଁ। ଏଇ 3 ଜଣ ମତେ ନିଆଁ ଲଗାଇ ପୋଡ଼ି ମାରିଥିବା ପାଇଁ ଯୋଜନା କରି ମୋ ଦେହରେ ପେଟ୍ରୋଲ ଢାଳି ନିଆଁ ଲଗାଇ ଦେଇଛନ୍ତି। ଏହା ମୋର ସତ୍ୟ ବୟାନ ଅଟେ। Then Milord, all the subsequently she died, Milord. And corroborated by every witness. Immediate neighbor, Milord, all are stated. ସେମାନେ ନିଆଁ ଲିଭେଇବାକୁ ଯାଇଥିଲେ, that means ନିଆଁରେ ଯେତେବେଳେ ରାନ୍ଧୁଥିଲା ସେତେବେଳେ ତାର ନିଆଁ ଲାଗିଛି। ନିଆଁ ପଛପଟୁ
Extending behind.
Milord,
how she is cooking.
ହଁ ସେ କୁକି ଆଉ ଗୋଟେ ମଧ୍ୟ ଅଛି Milord। ସେ କଲେ Milord page 34। ମୋ ନାମ ଦୀପକ କୁମାର ମାଝୀ। ଆଜି ଆପଣଙ୍କ ଠାରେ ଦେଖି ଦେବା ମୌଖିକ ବୟାନ ନେଇକି ଯେ ମୋର ସମ୍ପର୍କୀୟ ଭାଇ ଦୀନବନ୍ଧୁ ପାତ୍ର ତାଙ୍କ ବଡ ଭାଇଙ୍କ ଜଳଖିଆ ଦୋକାନକୁ ଲାଗି ମୋର ଏକ ଲୁଗା ଦୋକାନ ଅଛି। 2015 ମସିହାରେ ଜଗତସିଂହପୁର ଓ ଗୋଲକ ମନ୍ତ୍ରୀଙ୍କ ସାନ ଝିଅ ଡେଜନକୁ ପ୍ରେମ କରି ବାହା ହୋଇଥିଲେ। ତାଙ୍କର ଗୋଟିଏ ପୁଅ 8 ବର୍ଷର, ଗୋଟେ ଝିଅ 1.5 ବର୍ଷର ଅଛି। ବାହାଘର ବେଳେ କିଛି ଯୌତୁକ ଆଣି ନଥିବାରୁ ଘରେ ସବୁବେଳେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଝଗଡ଼ା ଲାଗନ୍ତି। ଗତ ତା
ଭାଉଜ ଚୁଲିରେ ଭାତ ରାନ୍ଧୁଥିଲା ବେଳେ
ଆଜ୍ଞା
ତା ପଛପଟୁ ପିନ୍ଧା ଲୁଗାରେ ନିଆଁ ଲାଗିବା ପଛ how from the back side fire will be put fire
back side ପିନ୍ଧା ଲୁଗାରେ ନିଆଁ ଲାଗି ଯାଇଥିଲା।
from back side where these people were standing cooking in the front
ଅଛି। ପରେ ଶୁଣିବାକୁ ପାଇଲୁ ତା ସ୍ୱାମୀ ଦେଢଶୁର ଯା ମୀରା ଏଇ 3 ଜଣ ତାକୁ ନିଆଁ লগাই পুরি মারি দিয়েছি। That is পুরি মারি file, my lord. I have rescued.
They have to explain how, where from the file came from, how backside.
That is not mentioned at the backside or front side, my lord. But near লাগিয়েছিল বলে কি
Backside is written that, if you read that, there also she said backside.
পছপট, my lord.
Both of them are saying পছপটে। পছপটে নিয়ে লাগলা কিন্তু।
Nobody, no,
to the kitchen.
nobody has
Kitchen.
nobody has seen the occurrence, my lord.
That's the problem.
How tapre?
What is petrol,
There is intention to murder, my
what
lord.
is the case?
Stage not just charge, charge of crime, my lord.
With material witnesses. Little material witness if you can. 6 months. Huh? Material witness 6 months. Remove the weight. Yes, next.
Congratulations.
55. Yes. Non-appeals for the petitioner, leave the matter after.
Withdrawal filed over flag, yes, but signature doesn't tell me.
That right on, withdrawal memo has been filed, which is placed as at flag T. Huh? Persons there to, the petition stands dismissed as withdrawn. Yes.
56.
Please, your lordship. There is unintentional typographical error in the order filed by your lordship, paragraph 2, last line of paragraph 2.
Which order?
26/9/24, para 2. Para 2 last line, it should have been executed for that. In place of para 2, not para 2. My lord.
Execution. Correction, yes.
57.
Yes, madam.
May I please, your lordship? Your lordship, we have filed the application regarding restoration because this is the transfer brief and previously the council.
When it was dismissed?
Your lordship on 22/6/2023, your lordship.
22?
6/2023.
23.
Yes, sir.
For the reason.
I'm appealing for the informant, my lord.
Okay, for the reasons stated in the application, the same is allowed. The
May I submit launching matter?
sheet 240 of 2022 is restored to its original file. Leave the matter for final disposal. Yes. Mr. Mahapatra enters appearance for opposite party number 2. Files Vokalatnama. Same is taken on record. Get
May I submit one thing, my lord? The matter, the prayer of the petitioner in that CRMC is question of the cognizance.
This happens. If somebody doesn't come at dismiss, no problem. Get ready. Get ready. Yes. Yes.
60.
Yes.
Time available.
Yes, your lordship. My lord, main application CRMC was filed for the expeditious disposal of the case, and your lordship had already passed an order targeting the case. But in the meantime, out of 3 petitioners who already died, who were suffering from the cancer, so for which there is again delay in the proceeding. And it is the cases of 2010, and out of 10 witnesses, 9 have already been examined, and only IO is yet to be examined. So, my lord, since that day when the order was passed, no.
What have you moved now?
My lord, I have already filed an IA I'm only paying for the targeting the case.
Already one order is passed. How many orders will keep on passing?
My lord, there is no progress in the proceedings.
Only IO statement is still recorded.
Yes, my lord.
And let it be.
My lord, since that order, nothing has been progressed, and only it is a
Because 2 of the accused have died. How you can't blame the trial court?
Yes, my lord.
Can the trial court could have stopped the death of these 2 accused?
No, my lord, but
If somebody dies, it has to verify. In that verification process, it took time. So how can you blame the trial court? How can you blame? You tell me. 2 accused persons were there. I passed the order. Don't pressurize the trial courts in that fashion. I passed there is an order. If the 2 accused persons have died, wait, have a little patience. They have to have verify whether they died or not, whatever.
The case is fixed.
Earlier order dated 12/3/2024 passed by this court. I am not inclined to entertain this application. Hence the same is dismissed. Our liberty is granted to the petitioner to move appropriate application before the trial court. For appropriate remedy. Yes.
61.
You move an application saying that expedite, there is an order.
Yes, my lord, on March.
You move another application before trial court. Very good. Yes.
61.
61. Nobody pays. None appears. What is this matter, madam?
Sir, notice served about,
Notice, sir.
notice is on service card located.
Notice on opposite party number 2, none appears for the petitioner. Notice on opposite party number 2 could not be served as per the postal remark. As per the postal remark, it reveals that the opposite party number 2 cannot be located. And let the petitioner file a fresh notice. Sorry, fresh address for opposite party number 2. This is the matter. Yes. Yes.
62.
Please, your lordship. Your lordship had issued notice. This is a
service complete.
This is a case where my lords. My appeal.
Nobody appeared. Okay.
Maybe.
Service. Yes. But last time nobody appeared for opposite party number 2. Okay, now fine.
Yes, ma'am. Yes.
Let's check it up.
Sarabchandra Pradhan seems to
Somebody is present in the issue. Okay, thank you.
Well, lordship, look at page 12 of the brief.
Is 12.
This is the impugned order.
Yes.
This arises out of a petition filed by me for committing the GR case to the Court of Sessions for being tried along with a ST case, which is the counter case. My lord.
Yes.
The court says, my lords may see, at the last part, the court says, my lords may see 6 lines from the bottom.
Yes.
On the above submission, he prayed to commit the present case to the file of Sessions Court for disposal according to law. Learned counsel for accused did not raise any objection to the said petition. Heard, on perusal of the records, it found that present petitioner informant Hon'Ble had lost the FIR registered as PS case 211 of 2020. Thereafter, the IO submitted charge sheet under the above said sections by charge sheet dated 29/11/2020 against the present accused, namely Govinda, Karunakara, Dasaratha, Jayanti and Shakuntala, and cognizance was taken on 27/11/2020. Thereafter, charge was framed on section so and so against the accused, contents of charge read over and explained, which they pleaded not guilty and claimed for trial. Now, out of 7 charge sheet witnesses, 2 have been examined. Thus, it is seen that from the record, that from the date of taking cognizance, 3 years has already passed. No petition has been filed by petitioner to hold the present case, that is GR 411 of 2020, as counter to the case pending in the court of the additional district and sessions Rajpati in ST case numbers 23 and 30 of 2021 in connection with GR 410 of 2020. All offences are triable by this court, as there is no specific prayer.
Yes.
To hold the present case as cross case arising out of the same occurrence, this court is of the considered opinion that petition being devoid of merit stands rejected. Now, your lordship may look at my petition which I had filed. The next page, page 14.
Madam, are you ready?
Yeah.
Huh?
Yes.
Are you ready or really ready or not? You tell me so that we will proceed. Otherwise, why we wait? Will you study?
Allowed me that, sir.
Oh, sorry, I'm not.
Allowed me that, sir.
Constant adjournment. Let it be ready, otherwise unnecessary. Get ready because I will only accommodate once. I told you. Interim to continue. Okay. On request of counsel for Mrs. Naik, counsel for the state, matter is adjourned to such and such day. Interim to continue. Yes. Prepare it because these are issues here. Yes. 62.
May I please, my lord? The matter of compromise, your lordship. My learned friend appearing for OP number 2.
Yes.
So parties are not here, your lordship may fix another date for appearance of both the parties, your lordship. They have already filed my lord affidavit along with Dinama.
No, but this is a POXO case 376 and everything is there.
My lord, but they have earlier got married, thereafter some disturbance taken place, that is 161 statement also was there. I have annexed, my lord. 161 statement.
We bring them after 1 week, keep it.
My lord, definitely fixed, your lordship.
Yes. Yes.
My name may be reflected.
No, so and so reflected. Yes.
64.
64. 64. Yes.
All the petitioners are in-laws of the approved petition number 2.
Yes.
Earlier, the husband of the approved petition number 2 moved before this honorable court in CILMC 4423. In that case, I have already submitted the filed certified copy of the FIR. Therefore, I have filed on a
to come to the main prayer.
The decree of divorce will pronounced on 12/4/2023. Marriage was legal between the approved petition number 2 and the husband of the petitioner. Husband. These are the petitioners are in-laws.
What is this case annexed to?
This is case arising out of matrimonial dispute. Earlier, the petitioner has obtained order from this honorable court in CRLMC 4423 under Annex 2 at page 17.
17? Now what happened there?
There a criminal proceeding was quashed against the...
Who is that Anupama Bhattacharya?
Anupama Bhattacharya is the son of the petitioner number 1. 1 and 2.
Oh, so they are the in-laws. Where are they? Where are they? They are here.
In this present case, petitioners are in-laws.
Are the accused persons are here around? What do you want? Did you follow what I'm trying to tell?
Question of the FIR.
Crossing of the FIR on the ground of settlement. If the ground of settlement, the informant has to be there and the accused persons are also to be present in the court. Where are they?
They have not come here, but the informant is now staying at Canada. Earlier case, she was appeared in VC and she had filed also in the civil proceeding before the learned judge family court. Joint affidavit was filed that after the settlement, she will withdraw all the criminal cases pending before the...
But where are the petitioners then?
Well, petitioners are not today here.
We bring them. I will, insofar as the informant opposite party number 2 is concerned, since she had already appeared through VC in the other case, where the husband was the party, I will exempt her presence. But the petitioners have to be there.
In the earlier order that has been reflected in your lordship.
Where is that? I know that she appeared through VC. That's
But what about the petitioners in this case? I am talking about that. Where are they? Why are you wasting time? I don't know. You know whether you understood or not. In the next day, you will come. That's what I'm saying. You bring the petitioners. They are the accused. The informant is in Canada. She had already appeared in this court through visual mode. I will exempt her. But so far as you are the concern, you should be here. VC mode or whatever. Bring them tomorrow. Why are you wasting? Tomorrow? Yes, bring them tomorrow. Yes.
65.
Yeah. Pardon. I have to take an instruction that earlier they were staying at Bangalore. Now either there is Bhubaneswar or Bangalore. I will take instruction that
I don't know what you know. How do I know?
I will take instruction to them. The material will be taken instruction.
My lord, appeal is pending and order for bail and stay of realization of fine but passed.
Item 62 दिला.
What 62?
Item 62.
What happened 62? You can't come in between. Tomorrow, but you can't come anytime you like. Some matter is going on. Please maintain the sanctity of judicial proceeding. At least we are in just highest court of the state at least. That's right. Please wait. He making a statement in between you. I thought you were opening something there. Please wait and take care of that. He also got scared. He thought that who is opening me.
My friend is there for CBI.
Yes.
My order was passed by the Honorable Court on 16/5/2006.
Yes.
Where my appeal was admitted. I was granted bail, was allowed on bail, and my fine was stayed. Thereafter, my lord, I appeared before the trial court. Since my sentence was 3 years, so I was admitted to bail to prefer an appeal before this honorable court. I went back with the certified copy and I was allowed on bail, and the fine was stayed. Subsequently, my lord, this October 2024, I came to know that an NW has been issued and it is before the police station for realization of fine.
Where is that?
I filed the entire order sheet off.
Now, where is IA? IA. You have moved in IA?
It's an
IA. Where is that?
IS 278, please.
Okay. For the reasons stated in the IA, 2786. The reasons stated in the IA, the same is allowed. The NBW order issued by the which court? Why?
But
order dated?
But it's lawfully see the rejection order, then only you can be refused because DW and thereafter NBW. The proceeding was started in the year 2000.
Tell me where is the order? I'll say that.
25/10/2024 was the order where my petition was rejected that I have filed the certified copy and my case is pending and it cannot come. This is once a while it has to be recalled.
Where is that order of issuing NBW?
Yes.
13 order dated 13/7/2020, 2007. NBW was issued for 13/7/2007.
Yes.
Is a stay till the disposal of the appeal. Appeal number? Appeal number
195.
194 forms. Is the appeal for hearing in the weekly. Get ready weekly.
My lord, Dr. Vidal sometime because they are going to bad time. His younger brother is in the last.
I am putting it in weekly. She will take it's don't worry. Yes.
Thereafter, the second is also like. Second is also
65.
66.
66 same order for the kid. Yes. Similar order. Yes.
68.
In 16, Lordship on the last page directed me to take instructions
Because out of 3 cases, in one case, final form was issued. And I have taken instruction in other cases also, police has given a final form that no offence is made also.
The instruction the first case, similar instruction have already been received.
There are 3 cases, huh?
Yes, 3 cases.
You challenge what? You challenge
FIR. At the stage of FIR, I had come.
And all the 3 cases, the final form has been filed.
Final form, yes.
Okay. Then I may know. In all the 3 cases, persons to, did I pass an order for instruction?
Yes, on the last date, that is 22nd October.
No, persons to the order dated 22nd October 2024. Instruction has been obtained by the State Council and please see it on record. On the instruction, through letter dated 3/11/2024 issued by the IIC Infosys Police Station, Bhubaneswar, reveals that a final form has already been filed in the present case. Therefore, nothing survives in the petition. Accordingly, the petition is disposed of. Likewise, all the 3 matters. Yes.
Please.
69, when this case, the last one was directed the state government to know the position of the GR case, my lord.
We have sent the letter.
The instruction
Last
is the instruction is persons to the order dated
last order, last of the University Department.
On 5th October, we have sent the letter to the SP.
persons to the order dated 4/10/2024. Instruction has not yet been received by the State Council, hence he is seeking 1 week adjournment. Lease the matter and so on, so interim order to continue. Yes.
71.
Yes.
Was I big violence? This is the matter where, my lords, there was a one-time settlement with the complainant bank.
Yes.
The settlement was done and thereafter, my lords, I have filed a quashing petition, my lords. I have concluded my arguments on the last occasion, Mr. Naik.
Yes, Mr. So this matter has already been heard.
My lords, for CBI, Mr. Sarthak Naik is there.
The Republic of.
Mr. Naik is joining. He's just informed me that he's joining, Your Lordship.
Yes.
Your Lordship,
Just wait then.
yes.
Because you are not seeking adjournment?
No, Your Lordship.
You have to answer it.
Yes, Your Lordship.
See, the only thing which you are supposed to answer is last time it is adjourned,
Yes,
if I remember correctly.
Yes, sir.
He is relying upon, you are relying upon the OTS.
Yes, Your Lordship.
In the OTS, there was a condition that it is but it's criminal prosecution.
Yes, Your Lordship.
He has been relying upon some judgment.
Yes, Your Lordship.
I asked a very pointed question.
Yes.
In those judgment, whether the similar condition in the OTS was there or not.
Yes, Your Lordship.
He has demonstrated from record saying that the Delhi case and the other cases which he relying upon.
Yes, Your Lordship.
There the similar condition was there.
Yes, Your Lordship.
Your Lordship, Your Lordship, both the judgments.
Yes, Mr. Naik.
Your Lordship, both the judgments are overruled judgments.
Huh?
The judgment which my learned friend is citing, both the judgments are overruled, Your Lordships. Lordship may kindly come to the judgment issue Narang. Yes. Both the judgments are overruled, and I'll also give the judgments. Lordship may first come to judgment 22/12/2020 issue Narang versus State of Kerala, Telangana.
Yes. Judgment.
Yes, Lordship. And Your Lordship may also, I'll give those judgments. Mr. Gaurav can note it down. One, Your Lordship's recent judgment of the Honorable Supreme Court by Honorable Justice Mr. Deepak Mishra and Bikramjit Sen, 2014 criminal Supreme Court page 3736. Exactly same issue, Your Lordships.
Okay. And
Exactly
what about
the same issue.
what about the two judgments he relied upon, High Court judgment? Those judgments are overruled according to you. Can you give the citation?
So one judgment, Your Lordships, one is the Supreme Court judgment, one is a High Court judgment, and two more judgment, Your Lordships. I was arguing a case before Honorable Justice Mr. Satrughan Pujari, your lordships, he himself had given that judgment. He asked me to look at this judgment dated 5/3/2019, your lordships, State of Madhya Pradesh versus Lakshmi Narayan. It says that Prevention of Corruption Act cases, your lordships, cannot be quashed irrespective of compromise, your lordships. So if there is a compromise, accepting without admitting for the sake of argument that there is a compromise between bank and him, your lordships, then also it can be quashed because PC Act is invoked, your lordships.
Give that citation also.
I'll give all the citation to him. Let him come back, your lordships.
Yes,
Examine them.
Yes, I just wanted to point out that Gyan Singh says that Prevention of Corruption Act, but if it has flavor of a commercial offense or
No, your
commercial,
lordship, this
then it
judgment
can
is after
go.
Gyan Singh.
I'll do that. And Malus, one more thing, BB Agarwal was a case of PC Act.
No, no.
Which
The
I
judgment
have.
which I am citing, your lordship, is after BB Agarwal.
But that is specifically over. I'll take it.
1 month after BB Agarwal. BB Agarwal was in February. This is in March.
It may be after BB Agarwal. Has it noticed BB Agarwal? Has it over BB Agarwal? You just check it out.
Yes. It has done.
Whether BB Agarwal is noticed in that judgment.
Your lordship, I'm reading this, your lordships. Your lordships, this is a 3-bench of the Honorable Supreme Court, which was passed after BB Agarwal. And it clearly states that the power is not to be. Lordship, may I read it? Then your lordship, he will challenge before 5-bench, not in High Court, your lordships. If 3-bench, then he will go to the Constitution bench and challenge it, not in High Court.
For academic reason, whether BB Agarwal has been noticed by the Supreme Court.
Lordship, Nikhil Merchant, BB Agarwal, everything has been discussed in this.
Then answer is that, yes.
I'll let me read your lordship only one line.
Not necessary, but noticing BB Agarwal and marching judgment. If one is taken by a bunch of higher strength, then that is what to do.
Maybe they are distinguishable ballots. Maybe they distinguished Nikhil Merchant as well as BB Agarwal in those cases.
But in Nikhil Merchant, the same issue has come, and therefore I asked. In Nikhil Merchant, whether in the condition.
Nikhil Merchant, we were not able to find out the OTS condition.
Your lordship, the BB Agarwal. Your lordship, 1 second. Your lordship, BB Agarwal has followed the precedent of Nikhil Merchant. Nikhil Merchant has clearly been distinguished here, your lordships. And the Supreme Court.
That is what I say. Like you have given enough homework for
Now Mr. Naik is saying Nikhil Merchant has been distinguished. There is a difference.
Such power is not to be exercised.
Give a comparative submission.
I have given my entire compilation to Mr. Naik. If Mr. Naik can give his entire compilation.
So that we deal with it. I'll take 5 minutes and distribute it and reserve judgment.
Okay.
And after 2 weeks.
So after 2 weeks is my brother's marriage. Is there? Let it come in January, your lordship.
But my lords, it's fresh in my lord's memory.
No, I'll forget it. I'll take 5 minutes, only the judgment part. Rest of the thing I know.
Could it be sometime next week, my lords?
It depends upon them. You give the comparison.
We'll give the comparison.
After 1 or 2 weeks, they do.
One short point, your lordships. If your lordships will remember, when this matter was listed last month, your lordships had asked him to file the OTS of both BB Agarwal and Nikhil Merchant, but he didn't do that.
He brought it.
OTS and also the consent decree, your lordship, so that it can be distinguished.
File those documents out.
Well, it's a part of the compilation. The Delhi High Court judgment of BB Agarwal has quoted the OTS
conditions,
which my lords had
pointed out that.
And the Chhattisgarh decision, my lords, which is also now handed over.
On the compilation, you just
I'll show
so that it will be easier for him.
Absolutely. Absolutely.
Next.
Well, it's 26th November.
26th. Okay.
Well, it's, if it could be indicated in the order that a compilation could be provided to me. Mr. Naik undertakes.
Mr. Naik will file, na?
Yes, ma'am.
Mr. Naik would file the compilation, convenient compilation for the purpose of final hearing, and by serving advance copy on Ms. Gaurav Khanna.
I also like to take the liberty of filing the complaint and the ECR of the ED cases also.
Therefore, I think that convenience compilation you can add whatever you want.
Yes. Because in the same case, he is also accused as for money laundering in the ED matter which is going on. That also I want to file. Yes.
Yes.
Right.
No problem.
Very good.
My lord. My lord, this is an application to what the FI in a vigilance case, my lord. My lord, that has been enforced by the annexure 1, my lord. The FIR was annexure 2, my lord.
Yes.
The FIR was lodged on register that was on 6/11/2013. And till today, charge sheet did not be submitted. FIR 6/11/2013.
Yes. Yes, Mrs. Das. 2013 FIR. Charge sheet has not yet been filed.
As my lord will kindly find from the order sheet, the Lawrence Council appearing for the vigilance has taken several adjournments on some pretext or other.
Yes, sir. What do you say? 2013 FIR. Charge sheet has not been filed.
Currently pass it tomorrow. I will ask Mr. Moran to.
Okay. Just pass it over. Yes.
Or else tomorrow.
I'll just pass it over. If it doesn't happen, then tomorrow. Yes. I am waiting. Yes, my lord.
73, my lords, I'm appearing. The school fee has been paid.
What is that? School fees.
Yes, school fee.
School fees.
School fee.
Okay. You paid.
Yes, it is paid on the 4th of November.
That matter.
Paid. Yes, my lord. My lords, may I say something at the outset?
Yes.
Just a thought, my lord. Since since an intervention application has been filed and the custody and the divorce proceedings are nearing completion, my instructions are the divorce case will be complete in a month's time. Custody will be finished in 2 to 3 months' time. The deposition, the evidence is complete. Now, in the custody case, we have taken a plea under 125 CRPC and the DV Act that adultery being proved, maintenance will not hold. So, my lords, that is one.
That plea you can take up today. You take
Yes,
that plea.
we have taken that plea. I just wanted to bring it to your lord's notice to have a holistic view of the matter since it has gotten slightly complicated now. I mean, for no reason.
You can't be, holistic view cannot be taken. Both of you are lawyers.
The new partner is also a lawyer, my lord. Now,
therefore, it is impossible.
There are too many lawyers involved now.
It is impossible. And matrimonial dispute between the lawyers and
a lot of, yes, that's right. Yeah, so Baba, the school fees has been paid, my lord, as per direction.
Okay. So what do you want now? It is paid by school fees is paid. He has paid the entire school fees. And when we coming, I don't understand what is his intention. He has not paid the fees for the dresses. He has not paid for the books. He has not paid for the transportation. Yet last time he asked for this, he paid it. Fine. Now the time has come. We must know what to do in this petition. I am coming to that. As far as this case is, and have they decided to fight it out throughout their life? Exactly. They will not settle. It can never be settled. That is the point. And many cases has come out of this. Now I am coming to the case as last time I told that we are not getting into the legal part of it. Now I say this is a case which is not maintainable. CRLMC is not maintainable against an order coming out of Section 12 of DV Act. This is the first thing we have to discuss right now here. To discuss this one, we have to see whether DV Act is a criminal act or a civil act as far as Section 12 is concerned. It has already been settled by Supreme Court that order of DV Act is purely civil in nature. It doesn't mean it is a quasi-criminal. It doesn't mean, but it's a criminal case. From that, I have gotten, if your lordship don't go by the technicality, come to the point, how to solve this problem. Because see, eventually we are spoiling the life of these young lawyers. 1 minute. And if they are fighting out for the sake of fighting out by reading provisions of law and all, life doesn't, you can't put on life by reading provisions of law. I just want to, marriage is a compromise. I want to put some facts. As this, there is some word called camouflage. This advocate is camouflaged. He is a
what to say?
I think time will heal everything. I will adjourn it. He is a
That's right.
manager.
We'll wait and lordships can await the outcome
He is
of
having
custody and divorce
three
proceedings.
vehicles. He has, this, what is the statement? Assets and liability statement, he has admitted. He has got 3 Mercedes Benz. His mother, director, himself and his mother, but has he himself earned? I don't think he that's good for them. Or you can concentrate. As far as law is concerned, he is a lawyer. The defense word, cannot please. Apart from that, what I said, this petition is, if you are not going to the technicalities, but this petition, what I learned out of these 2 cases, this petition, they said he is not capable of paying to 20,000.
I'll hear it. Hear it out. After that is simply adjourn. Now, since she has paid the last order, she has complied, I'll just simply adjourn and let us see. Give them little time so that
It's all right.
time will heal.
What I say is, who will ask to pay that small fees, some 30,000-40,000, then the small child.
The problem is for everything the court at High Court will.
My lord's endeavor.
I think what 125 proceedings is pending. And
Yes.
other proceedings are pending in the trial court.
That's right.
And that is going on at its own pace. I'm simply adjourning it. Let us see what is happening. Thereafter, I'll take a holistic view. As I said, it.
Not only that, we will go to that point, we'll go to legal part of it. Do that thing what the point. The child is debarred from education. Doctor and Gosiji. Our child say that she will be able to go to the school.
My lords, I have additional prayer to make.
Yes, Mr. Mitra.
I have additional prayer, my lords. I had instructions. I am personally of the opinion, since as your lordships indicated, lordships has been extremely indulgent with all the parties to find a amicable solution because the child is involved. I am not going to technicalities. I have points to argue. My instructions are since 1 year, the child is at the maternal grandparents' house and she is not being allowed to go to school since 1 year. I have the school attendance register since 1 year. Now, what is this? That girl is suffering. The child is suffering.
Everyone of us knows.
She can undertake till the next day. The child will be allowed to go to school. No, there is nothing as such.
I am not.
Let her go to school.
Mr. Mishra, you just tell me one thing. Have you paid the
Entire outstanding. Yes, entire outstanding has been cleared.
He says that.
Let her go to school. At least send her to school. She's staying with the maternal grandparents. The mother is staying somewhere else.
I don't believe someone. He said something. And you are taking I have been to school. And after the payment last order, have you ever verified?
They paid it yesterday only. Payment
nothing due then.
Dress upon transportation.
Everything is paid for.
This is no. I have got to say no.
The transport, the food, the tuition, everything is part of the fee.
But don't spoil the life of
Future of the child.
Why to stop the child?
My lord, it says tuition fees, transport fees, food charges, everything is paid. All paid. All paid.
Composite fee,
transport fee, food.
Transport fee, she has paid 12,000 rupees. Food charges, she has paid. What else you make? Don't tell all these things, please.
This is the composite fees, which is tuition fees. This is transport fees, bus fees, food charges. But they have not given the books and uniform.
Madam, composite fee include everything.
Everything.
Don't say that.
Tuition fees.
Don't mistake the code.
Okay, clarify. Let her clarify. Clarify next time. If that is the small amount, we'll pay it. Yes.
Nothing to worry.
Not small, you will not pay. Yes, she is paying it. Yes.
The child should not stay in the home. That is my.
They will not support because the entire thing is paid. Composite fee include everything.
Yes.
Let us check it out.
All of us parents who have been paying. We know that. And very painfully paying. In these good schools. So therefore we know what every line we see.
What is the money we pay, you know? Through our loan we pay to these big schools.
That I have supported a lot.
So therefore, you know, composite fee means including everything. And food, especially they charge for food and transportation also. If the transportation fee is paid, food fee is paid, why he is not going to school? Some reason,
Check up. Yesterday.
who is preventing her not to go to school?
The school was
That's right.
preventing.
No, it is not.
Yesterday.
No, it's not.
Now it is since now transportation food fee is paid, composite fee has been paid. There is no improvement now.
Now she can go.
And if she will not go to school, then somebody is preventing.
Exactly.
For what good reason?
Exactly.
You know that.
Exactly.
Yes.
74.
Lordship, 74 I am appealing virtually. The matter is posted before mediation on 15th. So this matter might be adjourned.
Sorry? Mediation is going on.
Yeah, the mediation is going on. Last time it got cancelled because of the cyclone.
Yes.
So the next date is
Mediation process is still on. Release the matter. Yes. Yes.
75.
No, please. Release of my vehicle order was passed till today.
Yes.
Lordship, the extra copies has not been.
And I have sought in court last occasion.
Lordship, it is not on the record.
You are supposed
Only to take instruction whether ye
now
eagle has been.
change of guard, you give extra copy. Now.
Yes.
Extra copy, least after 1 week. Yes.
76.
Lordship picks a short date.
Yes. One after 1 week.
Copy this.
18.
Yes.
Yes.
76.
Okay. Here I have challenged the order of cognizance and so also the entire criminal proceeding initiated on section 138 of the NI Act. Yes. You are accused by the accused persons. The petitioners and the complainant, they are having family relations, my lord. They were undertaking different business. During that business, it is stated in the complaint petition, my lord, that they have taken, my petitioners, they have taken 10 lakhs. 10 lakhs. You are the accused. Check has been issued by you. Yes, my lord. It's got dishonored. And for why for you have given what for the check got dishonored since it is an invalid check. Those things will be decided by the trial court. What can I do? You issue a check. Number here. What is the ground? One thing is that, my lord, one thing, Cognizance on section 138 and Act should not have been taken because it is not dishonored due to insufficiency, either due to insufficiency or insufficiency of the fund in the petitioner's account, my lord. Number two, my lord, the Cognizance should not have been taken. The petitioners, they are residing in a separate separate village, which is coming under jurisdiction of one court, and the opposite party, the complainant is staying within the jurisdiction amount, my lord. Amount 10 lakhs 50,000. Here, how much you owe, in fact? କେତେ ପଇସା ସେ ନେଇଛନ୍ତି କଣ ତାଙ୍କ ଭିତରେ ତାଙ୍କର ପଚାରିବେ କଥା ପଚାରିବି ପିଟିସନ ଇଜ ନଟ୍ ମେଣ୍ଟେନେବଲ ସୁପ୍ରିମ କୋର୍ଟ ନମ୍ବର 1 ଟିକେ ପଇସା ନମ୍ବର 1 these are all evidences which can only be tried before the trial court. Number 1. Number 2, it is not maintainable. Para 11 में kind of sin. Yes. Para 11. Yes. 482 is not applicable. Then other methods are there. There is a division. Division proceeding is available to him, and so 482 is not applicable. Number 2. Number 3 is
your lordship deciding a 482 in previously because supposing your lordship allows it, then you need to go to Supreme Court. But if the normal course is revision, if you go for revision, I have the course of this 482 again available to me. For all these three reasons, it is not applicable, may be dismissed.
A revision is another different. I'm giving two difference. Where the accused persons and the petitioner and the complaint, they are staying within the jurisdiction of separate courts, my lord. Inquiry on section 202 CRPC is required. Here, you forget about the inquiry law. These are 138 special statute matter. You issued the check or not? Yes, my lord. You cannot face it or pay it. These acts are designed for this purpose. These are summary proceedings. Don't read 202 and all. These are summary proceedings. Earlier, before 138 an act would not have been there, then I can understand 200 procedure, 202 procedure and all. A special statute is designed so that the technical or cases can be disposed of within 6 months. That's true. You bring so many things in 482 petition at challenging. Here the illegality, here the Supreme Court, so also the other court have given those decisions. Only that can be cognizance can be quashed and that can be remanded to the court, not that the entire proceeding will go. That is the purpose of that. When the two judges, you file, both of you filed this submission. I also filed. I also filed mine. These are the orders you have taken a stay in funding from your. No, here, no, but in the June. Anyway, I'll pass you. I'll pass you. Yes. Order this. Yes.
77.
77. How many matters are there? 29.
Mr. President, yes, Lordship Commissioners, I don't pray for adjournment. What I'm suggesting that my learned senior lords has headed a mentioning below. That's a short matter.
I'll take another 5 minutes. Only 2 matters are there.
77 lords to take some time.
2 matters. Only what is this matter?
It's a revision, lords.
Hearing matters. All 3 matters hearing matters. Then I'll have to give precedence to his matter. I'll hear. He says 3 minutes.
My lord.
By the time.
No problem.
Let us see. And you know the definition of 3 minutes for Mr. Rai. You know that.
The law is exact at 3 minutes.
Let us see.
Yes.
Give
written note of argument.
If you cross 3 minutes, then you don't have a case.
Yes.
You concede then. No, if you cross 3 minutes, then you concede that you don't have a case.
Yes.
If you have a good case, 3 minutes is enough for you.
Yes. My lordship would straightway come down to the first paragraph.
Yes.
Second paragraph.
Yes.
Thereby the rejection of the application for discharge, the abiding by his judicial function as the judicial officer, hence a criminal revision of so to quash the charges.
Error in calculation?
Error in calculation on the face of it, on record, error committed in calculating the income, failure on the part of the court below not to look into the undisputed accounts reflected in the charge sheet to have included in the
You come to that charge sheet where you said that there is an error.
It come down. Then relying upon the judgment of the Supreme Court, I have page 3.
Yes.
Page 3.
Yes.
The percentage of DA has my lordship got.
Yes.
Like 3 lines above.
Yes.
The FIR and the charge sheet and the disproportionate asset comes to minus 6.77
yes.
as per the formula on inclusion of the left out income as reflected in the charge sheet evaluation and exclusion of the figures of the arrival of the disproportionate assets. Percentage of DA is equal to disproportionate asset is equal to assets plus expenditure minus income into 100 divided by income. Now, if I get it below 10 and below, then I have to be discharged. Now we have to scrutinize as the reflection the charge sheet. Then I've given the lords on the face of the record what my lordship says to B.
whether there was any error committed on the figure reflection of the investigation in calculating the sheet of the petitioner and the income. It is to scrutinize on the face of the record. Petitioner will go to show that the prosecution cannot be permitted to blow hot and cold deliberately, not including income, and only opinion on hypothesis without any voucher or documentary evidence. To value a 11-year-old motorcycle, etc., which does not belong to the petitioner, but belongs to the petitioner's brother, that has been included. Now then I also could come down to the last paragraph. Search was conducted on 19/12/2018. Entertained the government on 5/10/2093 as a junior engineer, became an assistant engineer on 13/9/2013. The next page. Vigilance PS case 59/18 registered on 31/12/18. Made him liable for offence under 13(2), read with 13(1)(b) of the Prevention and Corruption Act, Section 109 of the Indian Penal Code. Now, my lordship, the total asset at initial stage in the FIR stated 81. Expenditure shown, as shown on the record, 29 lakhs. Known source of income is 46, as per the FIR. That is, now then during the period from...
Yes, Mr. Das, have you seen it?
Yes.
In the formula, he has given, see, read from page 4 onwards, comparative chart, and tell me. He says that if the calculation is made from the charge sheet, admitted position and the charge sheet, it comes to minus 6.77%. That's what his calculation is.
Yes.
Whether the calculation is correct or not, that is the only thing is to be seen.
That is all.
He says that take the charge sheet as it is. And some
139%. Then when they file the charge,
38.
Then when I see the income excluded, which I have given here, my lordship would see.
Number 6, minus 6.
Finish. My lordship see page 5. For the page.
I've seen it. I've seen it.
Giving the page number of the charge.
Can you please check it? If this is there, then he's entitled. This is not there. And he has given page wise.
Page wise and page number.
Please passionately check it. If it's there, you simply tell me.
That's all. My case, my lordship would say, Mr. Ray has concluded.
You have concluded. I am only going to listen.
He will only write and give it and conclude the case.
You check it up. Yes, Mr.
I've stuck to 3 minutes.
Give it.
I've given. I've already given.
You got it? Just check it up. You check it up. That's all. Calculation.
That's all.
It's a matter of calculation.
If the lordship permits me, may I suggest,
Not now. I'm not saying now. You please check it up. Because calculation may not go wrong.
I'll come back to lordship after verifying this.
See why I am telling you. FIR says 139%. Okay. When you file the charge sheet, you reduce 38%. Drastically change. But there may be mistake in calculation. What he is calculating today is coming to minus 6.7.
Why? Because he has left out the income of the one and taken into account of my brother's motorcycle. My which is here.
That may not be mine, yes. But in the same time, whether in the charge sheet, what they say, whether it is procured in money.
Single mistake.
And just verify because now,
yes, of course, verify.
Now, so haste. Lord, sir, I've received the call. Lord, I'm obliged to him, Lord. I'll go through and come back to Lordship with regard to verification.
No, you let me
bear with me much more. The entire submission of Mr. Roy Lords, can you just tell me on a particular documents and notes whether the accused Lord or the state of consideration of discharge application is entitled to submit any documents now? Or all the documents or the material produced by the prosecution at the time of consideration of discharge law is accepted as proof. Even mention of the accused Lords will go to the material produced by the prosecution at
I'll tell you, the answer is the very fact that we are prosecuting someone for disproportionate asset. Disproportionate itself indicate that some calculation is to required. If you have filed a charge sheet, by mistake some calculation has gone wrong, we can recalculate and decide it.
That's
because disproportionate. How do you determine disproportionate? You are not going to rely any document beyond the charge sheet.
Can this delve into the matters? I request a courtship can bear with you and place one line blocks. It's a judgment of Supreme Court.
Yes.
And this case is potential also gone to state of versus R. Sundar. So I place it in that executive matter. I'm placing paragraph 78 plot. And it says, Lords, on this particular proposition, the High Court acted completely beyond the certain parameters as discussed above, which govern the power to discharge accused from the prosecution. The High Court could be said to have, is important. The High Court could be said to have done the role of a chartered accountant. Listen, Lord, this is exactly what this court observed in the case of Thomarallu versus Vijay Lakshmi versus T.S. Vijayalakshmi Supra. The High Court has completely ignored that it was not at the stage of it's not a stage of trial or considered an appeal against a verdict in a trial. The High Court has inquired into the material produced by the accused persons. Now they produce their matter. And my lunch seniors will not pushing that should be inquired into the High Court. The High Court has inquired into the material produced by the accused persons, compared with the information compiled by the investigation agency. Now it's been compared with the charge sheet and pronounced a verdict saying that the explanation offered by the accused persons deserves to be accepted, applying the doctrine of preponderance probabilities. The entire
I understand it, what you are saying. The court can't be chartered accountant, evaluate everything. But if the court finds in the charge sheet, if it is written 2 plus 2 is 5, can't the court say that no, it is 2.2 is 4, not 5?
My point is, Lord, that particular word chartered accountant also deleted words. My point is, Lord, the entire.
I will not refer to anything. Only I'll see whether calculations are correct or not. If I do that,
I may submit, Lords. The second position, Lord, all these documents produced, Lord, we are in the stage of consular discharge application. All the produced by the prosecution, that is charge sheet, Lord, it accepted. This is a settled legal position. Well, I'm not saying for my own. No, this is settled legal position. It's to be accepted too. If there is anything, Lord,
I respectfully disagree. Whatever police throw on the court can't accept it to be true. Court officer has to take a view. That's what I'm giving an example. It's 4. If the IO writes 2 plus 2 is 5, then you say that no, you have to take it to correct and proceed.
Well, I humble
the court is so helpless.
No, this is a fitness what to request.
So therefore I'm saying, that's what I'm saying. None of the documents which he is going to rely upon today, I'm going to take into consideration. The calculation part. If the calculation part is a disproportionate.
Your logic is correct, the court is not like a post office moves. The court has to apply minds lot. Now, this particular thing is permissible lots on a 482 lot. That is a what I suggest lot. I construct of all the submission put for my lots can be completed in 2 lines lot. That these are the documents I am placing before this honorable court, before the Lord High Court, indicating the my total the amount is less than 6.77.
Where is the document relying upon? No, not relying upon any document.
This is a submission.
Submission is not relying.
That's well, I'm not kind of with him. I read this. The Lordship is
relying upon the calculation.
This submission is placing lots. This expression hearing the submission accused. The expression hearing the submission accused cannot mean opportunity to find materials to be granted to the accused and thereby changing the settled law. The line starts at the stage of framing of charge. Hearing a submission, the accused has to be confined to the material produced by the police. So, any submission of the accused at the stage of consular discharge application, the trial court or this corner court should pertain to the material produced by the police. This is the set legal position, not I'm placing.
Don't go by what Mr. Rai, he writes such a kind of English, nobody can match with that. Don't go by his English, come to the calculation, mathematics. Go by his mathematics, don't go by his English.
Mathematics, where is it wrong, Milords? That's I want to know.
That's why you just check it up. If it is not wrong, not wrong.
No, still, I am happy if I enlighten which line and which.
No, just see. You come to page 4.
Page number 1. What is the page?
Don't hurriedly do it. I'm just telling you. Page 5 onwards, you are given pages. Yes, let's check it up. Don't rely on any document which is going to file. I am not going to touch any document beyond the charge sheet. I'll only see whether 4 is to 4, 2 is to 2 is 4 written or 2 is to 2 5 written.
I come back.
If it is 2 is to 2 4 written, no problem.
I will assure this one. I'll come back to Lordship with verify this page 5 and 6. But I'll be happy if my enlightenment of which particular serial number. Page number. 5 number. So many things are there.
No. You have read it. I have checked it up. Just 5 you come to page 4 in the comparative chart. Okay.
Comparative chart.
Got it. He has given this calculation. That means charge sheet. No. This is charge sheet calculation. This charge sheet calculation, it says 38.59. Okay? This is no problem. 38.
No problem.
FIR was 139.
I agree.
Thereafter, he gives pages.
Page 5.
In this page, this happened, and all. You just verify whether it is to be relied upon or not. And thereafter, at the end, if you come to page 6, please come to page 6. Page 6, as per formula, as per formula, he is giving this calculation. This calculation, according to you, is correct or not? Just see, check it up. Very simple. If it is correct, then he has a case. Something has to be deleted. Do it and say that go and change the time. Simple. Simple.
I only show you one of the rules of business. One. Only one minute.
All these things I may not go into this.
Rules of business.
Okay, you give it, no problem. What's
approval of and approval for? My Lordship sees the distinction.
Nobody is relying upon this system. Nobody is saying,
Here, after finding the only approval. Indra Jai Singh, my Lordship keeps this for my Lordship's record. Jai Singh argued it was thrown out by the Supreme Court. He said you are filing the charge sheet, taking the approval after filing the charge sheet, violating CL 11 subclause 2. And it was approval of the charge sheet for prosecution. That is prior to the prosecution, you have get approval.
I don't understand. What is approval?
this is for.
It's my Lordship keeps it.
Yes. Well, give the book.
My Lordship keeps the judgment.
Judgment I will give. Judgment.
No, go to the citation.
Citation. Close. Okay, thank you.
I'll answer. I'll
give it. I'll find out and give it.
My Lordship can conclude this case from
No, from his side is continued. Yes, of course. He will. Yes. Mr. Rai has concluded his argument. Mr. Das seeks an accommodation for the purpose of answering the argument and to answer the press written submission served to him today in the court. Leads to matter. Yes. Yes. 113.
72 can it be taken now? 72. My lord, he has to take simply.
Yes, 72. Yes.
Whether that has been submitted or not in that case.
72, just check it up. You have.
In that case, my lord has given them opportunity on 22nd April 2024 for 3 months time to.
2013 FIR.
I got it. I got this one. I contacted Mr. Mahara. Is another.
He is very much, but he found that matter has been
Only you have to tell me whether I'll keep it on Friday. Friday I'll keep it. Friday, please give the instruction. Give the instruction. Friday.
It was 72.
72.
But the charge sheet has been filed or not?
2013 means the FIR. charge sheet has not yet been filed, therefore he has come to this court for quashing, for delayed this thing. You have to tell me why it is not filed, whether he is responsible or who is responsible, what is happening.
Delay attributed to him
Yes.
or to both.
Now, if you don't want to file charge sheet, it's very good. Finish it up. Because after so many years, what?
My lord has given several opportunities.
See, many hearing has taken place.
Item 8 notes. 8.
72.
8.
72.
80.
80.
80. The witnesses might have been died now.
Correct.
Some of the accused also.
One became, many things happened.
2013 or 2024, 11 years. Yes.
Is it a DA case? Then okay.
Again?
The key case. Misappropriation.
Check it up.
DA case delay.
Prosecution may not be interested also.
No, sometimes DA case delay, but misappropriation.
Misappropriation case, but why they delay? I don't know. Yes.
Honorable Court directed towards 60.
Sorry. Yes. Huh? 60? 62.
In fact, my lord.
Holiday agent. The request made by the government council because date is.
My lord friend was contesting as a MLA candidate from Aam Aadmi Party Cuttack constituency.
We should be chief minister. He will be chief minister sometime.
Aam Aadmi Party candidates for Cuttack constituency last election.
That's what I'm saying. He will be chief minister. Why are you wasting time in small matter? You will do better job. Leave it. Let it be adjourned for January or something. Okay. Yes. 77.
Please, Your Lordship.
Yes, madam.
Challenging Annexure 6, that is the dismissal of discharge petition, my lord.
Yes, Ms. Das, you are ready?
I'm ready, but I'm hungry. I'm ready, but I'm hungry. I'm sorry, my lord. He has been waiting for this for pretty long time. I agree with you, my lord. I'm also ready, but that has a checkered history, my lord. That's going to take time. I could not take anything during lunch hour. But so for the next case, Mr. Senior Advocate, Mr. Mishra is there, my lord. In that case, my Mishra supplied me assured me to supply the copy of the documents containing all the RT information law. That also pertains to a discharge application rejection that for a revision of my senior advocate, Mr. Mishra. But I got the copy of a bunch of copies on 29th law. Then subsequently the holidays followed. But I will be happy notes I'll have discussion with the Mr. Which portion of that particular bunch on which I have to take instruction. I could not take it. I got that copy. Yesterday I said talk with me.
It's simple case. The director's note.
You really can make it simple. You make him understand to make it simple.
On which page? That's why I will take this.
Which is why.
Essentially, what he says is both the matter he has an adjournment because he is hungry. Essentially,
I just make a small prayer, my lord. This matter is a very.
Yeah, right. Since this is a vigilance case, we can't also offer him food here.
Section 7 law.
So,
we are scared.
No, in fact, I love to show it in notes. Well, in fact, he is a epitome of the person having ethics in the profession. I learned many things from him, despite the age factor and all this thing. My learned senior also has gone through a very traumatic situation. She lost her father, the home and everything. Now she takes care of her mother's also. And for this particular case, he has come thrice more. I appreciate her anxiety.
Then, shall I put it tomorrow for him?
Let both matters be there tomorrow.
Let it be rolled over. Let it be rolled over. Okay. Yes.
Instructions comes in. I need yesterday. Let it come tomorrow. I'll get instruction on that.
You mean Mishra's matter or her matter?
That matter I'm ready. Let us start tomorrow.
It may come tomorrow, my lord. It's lingering since a long time.
Same case, only 8.
Tomorrow there is no only so this will come to last.
That is, what he says is tomorrow if it's still over, it may not be, it's better that it should be on 8th. Right.
My lord, my lord.
So there is a
May,
chance
may I request to fix the time at 2, my lord?
Agreed.
No, make it 3. 3, not
My-
2, because 2 password matters and all
My-
that come.
my-
Make it 3, okay?
My-
3 o'clock? Right.
Okay, sure.
Yes, what to do, Mr. Mishra's case?
I'm grateful to my Mr. Mano, he has flagged by all the places on which he relies on. I take instruction. This is pertaining to.
When shall I keep it?
You have given a note also. Meaning, so the note explains it.
Note again.
When shall I keep it, you tell me. What are you on 13th? 13th होगी huh? Saturday. 30th. Shall I keep it on 30th? Because Saturday, working day. Without any problem, we can conclude it.
Mr. Mishra,
No, 30th is a Saturday working day. 30th. 2-3 matters only keep on 30th. Don't only hearing matter. So 2-3 matters we'll hear it finish up. Yes, that's what I. Yes.
79. Here, my lord, both the appeals arising out of one special case, GR case. And here, my lord, the present appellant, my lord, convicted for commission of a 20B2C for my lord 10 years and fine, my lord, 10,000. 1 lakh, my lord. That is, my lord, judgment in running page, my lord, 39 and 40. And in this case, my lord,
How much you under?
already 3 years, my lord, have 37 kg. Till no weight. And my lord, in this case, my lord, I have taken certain, my lord, grounds. That is, my lord, 42, 1 not complied. And my lord, 55, my lord, safe custody of ganja. And more, my lord, 52A, 2, my lord. That is, my lord, collection of the representative sample before the concerned magistrate. But in that case, my lord, on a perusal of the evidence of the PW 17, that is, my lord, informant.
But this is the appeal of 2024.
Since it's a
Why it is-
special assignment, my lord,
Why it is taken up in the community list?
it's the, my lord, Chief Justice minutes, my lord. It's a special. It's not assignment to the my lord, my lord.
No, this is criminal appeal. Oh, appeal.
Yes, my lord.
Okay. It's not vigilance appeal. Okay.
But it's, my lord, special. The honor of the Chief Justice, my lord, it's special
Oh,
assignment.
1 minute. Where is the assignment? Okay.
Because it was earlier before Honorable Justice, my lord, Honorable G. Satpathy, and my lord, since my lord, the trial court conducting advocate, his my lord relatives, that's why my lord he.
Then again, it's the same thing on 30th. Because they have to meet it.
Formula written note.
Give.
With my lord, yes.
Get ready. Saturday. We'll finish it up. Special assignment, we'll finish it up.
Is a written note, my lord, today for
Keep it in mind that recovery is about
37.
37 kg of ganja. He has been convicted. He has already undergone about 3.5 years. And
My case, my lord, mandatory provisions has not been complied, my lord. In view of the evidence of the PW 17 and 18, as well as the my lord 13, concerned executive magistrate.
sufficiently penalized. That keep it in mind. Someone find out the way to,
ବେଡ୍ ହଜିର ପତ୍ର ଆସିନଥିଲା 6 ମାସରେ ମୁଁ 4 ମାସରେ ପାଇ ଯାଇଥିଲି ତାର ରିଜେକ୍ଟ ହେଇକି ରହିଛି କନଭିକ୍ସନ
he years you remain in jail despite 37 kilo. What is you must be having antecedents.
No antecedent. ମୁଁ ବେଲ୍ ମିଲର ରିପ୍ରୁଭ୍ ବାଇ ଦିସ୍ ଅନେବଲ୍ କୋର୍ଟ ଦେନ୍ ମିଲର ଆଉ ବେଲ୍ ଫାଇଲ୍ କରିନି ଆଉ ଟ୍ରାଏଲ ଓଭର ହେଇଗଲା 3 ବର୍ଷରେ.
Because that was the reason where NDPS means no bail. Now the regime is changing.
ମୋ ବେଲ୍ ଆପ୍ଲିକେସନ ପେଣ୍ଡିଂ ଅଛି ସେଇଟା ବି ଶୁଣାଣି ହେଇଗଲେ ହଜୁର ହେଇଯାନ୍ତା ଆଜି ମାଇନର ପିଜେଡ୍ ହିୟରିଂ ହେଲେ ବି ଖଲାସ ବି ମ୍ୟାଣ୍ଡାଟୋରି ପ୍ରୋଭିଜନ କମ୍ପ୍ଲାଏ କରିନାହାନ୍ତି. Apart from that, my bail application also pending.
Pending. Will dispose of the appeal.
Yes, that will be better. since the outset.
Okay, thank you.